Matter of Shank versus Shank. Mr. Shank is present, as is Ms. Shank and her attorney, Mr. Keeler. This is a motion to change custody, parenting time, and miscellaneous relief filed by the plaintiff. The judgment of divorce had joint legal and physical. That was from September of 2023. It's clear here, father's been arrested. He's in the Kent County Jail, and counsel, I understand that he's being charged with assault intent of his girlfriend back from February. Was the charges, numerous allegations you've made in here to find obviously proper cause or change of circumstance, so we can have a evidentiary hearing on change of custody. I think I stated what you put in your motion pretty succinctly. You need to add anything briefly. There clearly appears to be proper cause or change of circumstance based on your pleadings. But I'm going to give Mr. Shank. Mr. Shank, is there anything you wish to say?
Yes, sir. I'm asking for this hearing to be postponed due to not having.
It's going to be. I understand you want a court-appointed attorney and whatnot. They do not have them for this. There are no court-appointed attorneys for this type of hearing. This is a properly noticed hearing that it is set, and quite frankly, you're appearing here.
Okay, I'm a disabled military veteran. I've been trying to get along and contact the Veterans Justice Office, and I was told to contact legal aid, and I have no funds to be able to do that. And I
can't put this off just because you don't have an attorney. It's up to you to get it. We do not appoint attorneys for custody matters such as this. You can seek assistance wherever you want, but literally your request would mean we would just sit on this indefinitely. I have no idea you've had.
I'm not asking for that. The Veterans Justice Office advised me to contact legal aid, and because of the way I've been trying to. I've tried multiple avenues. I mailed friend of the court, contacted court services here. The phone systems here do not allow us to use the automated phone systems of these legal aid services, and so there was nothing I could do to get through to them. The phone systems here don't allow us to use the.
You're in your situation because you're in your situation.
I haven't been charged.
We cannot put you there. We're at a situation where, quite frankly, I'm only going to order that there is a proper cause or change of circumstance from Bud Barca. Clearly, plenty of it due to the assault charge against you, the matter that you're there for, and that the child was at the home during all of this, and that it is. I'm going to set up an evidentiary hearing for change of custody. I can't change custody on a Friday morning, so I'm going to set it up for an evidentiary hearing. We'll get notice out to you. I'm sure you'll probably be transported down here for the evidentiary hearing because it'll be in court. You'll have it.
Can you explain to me what that means, the evidentiary hearing?
It means we're going to have a hearing to determine if change of custody should occur.
Okay.
So, that's what I'm ordering at this point. The second part, Mr. Keeler, you have asked for return of certain documents to your client. I have no idea how to do that. Quite honestly, I don't know. I don't want her in his house rummaging through stuff to find it.
I can try to have that done. I have somebody renting my house, and so I can contact them and I can have them sent to you, Nina. I can do that.
That would be great, but Mr. Keeler, other than that, I don't feel comfortable. Even if I were to grant the motion and say she could be accompanied in there by a police officer, okay, she'd still have to rummage through his stuff, and I don't think that's appropriate. Certainly with the charge that he has against him and things like that, I don't know what is relevant, not, and all that kind of stuff. So it's not. Mr. Shank has said that he will see if he can get it to you. That's probably the best that'll happen this time. So
thank you.
For your second part of the motion for relief, I guess I'm technically denying it because I don't know how to accomplish it. All right.
No, I understand, Your Honor. Thank you very much. We understand it's a little bit of a novel situation. Obviously, in normal circumstances, Mr. Shank could just hand those over to her, but that's not what we have here. Should I put it, I mean, I assume that you would you need me to draft an order or something that says that Mr. Shank will try to cooperate with a third party known to Ms. Shank to have those documents turned over?
That's fine. You can do that because he stated he will, but I don't know of anything else that we can do. You can even draft the order and just say court will order an evidentiary hearing regarding custody and that other part. We'll send out notice to everybody.
Okay.
Any idea when your criminal case will come up, sir? I have no clue, but
What's that, sir?
you have to do the best you can from jail. All right. Thank you very much. We're adjourned.
Thank you very much, Your Honor.
1 DP Campbell versus Dykstra. As I say, both parties are present via Zoom as well as from the prosecutor's office, Ms. DeHaan. This is a request by Ms. DeHaan to enter a judgment of paternity as well as a UCSO. Ms. DeHaan, I don't have anything in my file that shows results from a DNA.
I can have those sent, Your Honor. Yes, DNA test was completed. We do have the results.
Did Mr. Dykstra get a copy of it?
I do believe so.
All right. I mean, you're not going to lie to me. It was 99.999% that he is the father. Is that the finding?
Allow me to pull this up. Yes. Sometimes there are a few 8s in there as well. I am pulling up. It is 99999. Quite a few 9s and then an 8 at the end. But yes, it is a 99% chance.
Yeah. All right. Mr. Dykstra, do you dispute the fact that you're the father?
No.
All right. We'll enter the judgment of paternity. He's in jail. I don't know how we can't really collect child support from him at this point.
Correct, Your Honor. I did submit two proposals, if you will. One in the event that he remained in custody for today's hearing, one in the event that he was released, as I was unsure of what's going on in the criminal matters. The proposal in which uses the incarceration language, I do believe that is my marked proposal too. Hopefully that made it to your desk, Your Honor. But that UCSO just reserves support until such time as he's released. And he can reach out to the parties can reach out to front of the court to make sure that child support is appropriate in the matter at such time.
Mr. Dykstra, do you understand what they're saying? They aren't going to charge. Do you have a release date?
No, not yet.
I'm sorry, not yet?
No.
All right. Ms. Campbell,
I might be posting bond next week. I'm not sure yet though.
I'm sorry, what was that?
I might be posting bond next week. I'm not positive yet though.
All right, well, if you get out, you're responsible to contact the front of the court then to start basically paying child support. But until you're out, you don't have to pay any child support. We don't collect any, you won't go in arrears. All right, so, Ms. Campbell, I don't know what you would have to add. The judgment of paternity will be with Mr. Dykstra, and from there, he will be being charged 0 child support when he gets out. You can always not contact the friend of the court, and they can look at starting some type of child support.
Okay.
All right. All right, Ms. DeHaan, you can send those to me through DocuSign. The second one, the UCSO being the one that does not charge because he's incarcerated.
Thank you, Your Honor. I'll also have another copy of the DNA results sent to the court.
Good. Thank you.
Due to that oversight, I apologize.
Okay. That's okay. Thank you, everyone. Good luck. Have a good day. We're adjourned.
Thank you, Your Honor. Have a great one. And have a excellent weekend.
Mr. Lambert, can you hear me?
Yes. Can you hear me?
Yes, sir. Ms. Axdorf, I think she's connecting, hopefully.
It's not easy. It doesn't give you the controls until it starts.
The wonders of science.
Yeah, but when you're not used to it, it's kind of difficult.
I will agree with you. I'm not very good at the technical end of this.
Yeah, my problem too.
And apparently her problem right now. Ms. Axdorf, can you hear me? You're on mute. Can you hear me?
I can hear you.
I can hear you. This is a matter of Axdorf v. Lambert. This is a motion filed by the plaintiff, Ms. Axdorf. Motion says to avoid missed parenting time. In essence, she said that there's an order, which there is a court order, that she gets 1 week in June, July, and August. Must give notice by May 1. The order kind of says May 1 of 20 22, because that's when it was, but it's clearly meant to mean by May 1 of each year. If you, ma'am, I don't know what else you want to say, but if you gave appropriate notice by May 1, you get 3 weeks of summer parenting time. I'm not, and there's nothing more to say about it. It is in the judgment. It is there. If it doesn't happen, you can file with a friend of the court and ask for contempt. They'll look into it and we'll deal with it from there. I mean, I don't know what you're really asking. It's in the judgment.
Your Honor, there is on this order that she is to receive 7 days per month. Ms. Axdorf's request for August has her receiving almost 20 days for that month. As default in this order, summer wording, my son is to be returned to her the evening before school starts. That would give me my full 3 weeks. And the defendant 10 full days in the month of August, as she had last year, if she makes the exchanges on the weekends, which she did not. Ms. Axdorf failed to make those weekend exchanges in August of 2023.
I'm not dealing with August of 2023. I'm just reading the judgment. I'm not making any orders. If she gave proper notice,
Her request,
you will have yours and she'll have hers. And if it doesn't work out, I'll get you in front of.
It's for almost 20 days of parenting time in August.
She gets 1 week of straightforward, no interruptions, 1 week in each of the months.
Yeah, that is to be 19th through the 30th in August, as documented by the return date of school. The summer parenting time specifically states the defendant shall have parenting time for the remainder of the summer, commencing when school releases, which is today, and ending the evening before school resumes. That date is August 18th this year. That date would give Ms. Axdorf a total of 10 parenting overnight days. Ms. Axdorf is requesting an additional 7 days in the beginning of August. This is the issue.
I'm telling you, I don't send out advisory orders. I can read this judgment just like you can. If you violate it and you end up in front of me and you have violated it, I'll hold you in contempt and she will get extra makeup time. If you didn't violate it, then you didn't. I don't, it's off in August. I'm not getting into what's going on. I can read this. The defendant shall have parenting time the first 3 weekends of every month, with plaintiff having the 4th weekend rotating. Weekend parenting time shall run from Friday evenings until Sunday evenings with exchanges at 6 o'clock. Plaintiff shall have all other parenting time during the school year, with the exception of the holidays. And then it says summer. The plaintiff shall have the parenting time for 3 weeks during the summer, to be exercised in 7-day blocks of time, 1 in June, 1 in July, and 1 in August. Plaintiff shall provide you with all that time by May 1. Defendant father shall have parenting time for the remainder of the summer, commencing when school is released and ending the evening before school resumes. That's what it says. That's what you guys will abide by. If there's ma'am, if you think he violated the court order, you file a complaint with a friend of the court, and believe me, I will deal with it at that time. But I'm not going to deal with something that's way out there somewhere that may or may not occur. So I'm going to have to, basically, I'm denying your request to avoid misparenting time because it hasn't happened at this point. If it happens, you can contact the friend of the court, and if you don't get appropriate relief from them, then you can file a motion if you think it's appropriate, but it's way too premature. So at this point, I'm just going to say that this is not, this motion is not timely.
Okay.
Good luck, everybody. Thank you. We're adjourned. DC Gladstone versus Rasmussen. Both parties are present. Ms. Quist representing Ms. Rasmussen, Ms. Sierra representing Mr. Gladstone. This is a motion to modify custody, motion for psychological evaluation, motion regarding counseling, etc., filed by the defendant. I've read the motions. I've read the responses. I have what I'm planning to do, which is not to necessarily grant anybody's motion at this time. But I've been involved with this case for years. I had evidentiary hearings and stuff. I'm more than familiar with both parties. Both parties have had different attorneys went in front of me and all that kind of stuff. I'll give you council, I'll give you a chance to say something, but quite frankly, what I'm gonna do here today, because I've seen a steady progression of this child being screwed up by two parents who are miserable parents and work for themselves and not for the kid. As a result, this child's been in counseling. He's only 11 years old and been in counseling for years, and we can't even get a counselor set with him. They've done an awful job. So what I'm going to do is I'm going to put in a guardian ad litem to get to the bottom of some of these things, and see what I can do with that. I'm also going to appoint a counselor, because both parties apparently they can't keep a counselor and can't agree on a counselor and whatnot. You can renew this motion in the future if you would like, but for right now, it's my intent to appoint a guardian ad litem. I have picked, although I have no, Stephanie Kirkstra is a well-known person who does this. If she will accept it, I'm going to appoint her as a guardian ad litem for the child. I'm going to appoint a counselor. I know in one of the pleadings, there was something that was sent to me about a counselor that would be appropriate. I'm going to, if she can accept it, and if she's available, I would like to appoint Lynn Jackson. Was one of the requests from somebody made. And again, I have nothing with Lynn Jackson. I've seen her work. It's been fabulous work in the past. I'll appoint her, but council, you're going to have to contact her to just make sure the court's not going to make sure that she can and will accept this. Okay.
Will do.
If she doesn't have time or whatever, you can, either the two of you can pick a separate counselor or come back, and if you guys can't agree, it's up to me to do it. So you can come back with choices if you cannot agree on a counselor. Same with the GAL. If Ms. Kirkstra can't or won't accept it, we'll have to find somebody else. But I do intend to appoint this. This child needs a guardian from both parents. So I'm going to appoint Ms. Kirkstra. You will be responsible to, your clients are each going to have to pay half of the guardian ad litem's fee. They will, I don't know what her fee is. I have nothing with Ms. Kirkstra other than to know she has a great reputation, and I need somebody with a great reputation. You'll be responsible to meet the, whatever her retainer is within 7 days after she is appointed. I'm appointing her now, but you got to contact her to make sure that she can and has the time and will take it. All right. So that's going to be the order of the court, but I understand that that's not necessarily what everybody was really asking for. Ms. Sierra, I'll let you put something on the record if you really feel like you need to.
Your Honor, just very briefly, I certainly understand the court's ruling and respect the court's ruling. At the end of the day, my client's top priority is to make sure that this child is protected and being safe. And I think that getting to the bottom of what's going on here is truly what we need to have happen. The history here is vast. And I will just very, very briefly say that I think that upon reviewing all documentation, I think that the truth will come out. And
that's my hope.
Yep.
I'm not going to find the truth today, I'll tell you that, with emotion. And so, and as I say, I'm more than familiar with the parties in this case. And I don't want to say anything more because it won't be positive. Ms. Quist, is there anything you'd like to add?
Not really, Your Honor. I've looked at the register of actions and I was surprised at the history of the case and how long and in depth and how many attorneys have been on this case and how many things have been filed. So I'm pleased that we're going to have a guardian ad litem on this case. I would just like to clarify, it's a regular guardian ad litem, not a lawyer guardian ad litem.
At this point, just a guardian ad litem. And I do, if there is some conflict with either person that I've said has got to be appointed or something like that, obviously we'll have to revisit this, but it's my intent at this point to put a guardian and a counselor in. Okay. And then anybody can renew this motion once you've got the guardian ad litem's report or something like that, and something that I can work with.
All right. Thank you.
And so, like I said, because I didn't even really give you a chance, I've read everything. I do want to give you a chance if you want to say anything for the record for any appeals or anything like that. But I'm gonna try my best to get to the bottom of this.
Referee Frederick, I appreciate the appointment of a guardian ad litem, and I also look forward to answers. I think Stephanie Kirkstra has a fantastic reputation. She's been on a couple of my cases as a guardian ad litem. And I think she'll do a great job. And I also would like to state that it's my client's highest consideration, the well-being of her child and of the child of the parties. I think we have a little girl who needs both parents to be functional and both parents to be healthy. And I think a guardian ad litem is appropriate here. Thank you.
Thank you. So I guess neither of you have any objection necessarily to what I've done here today.
I do not, Your Honor.
No.
All right. Thank you all very much. Is somebody going to draft an appropriate order? Because I'm not going to.
I can.
All right. You can draft it. And I think Miss Kirkster requires a signature on a GAL engagement letter or something like that. And I'm also telling you that when she tells you how much it is for a retainer, you got 7 days to provide it to her. I'm not going to let her do this for free. That's sure. All right. Good luck, everybody. Thank you very much. Have a great weekend. Appreciate it.
Thank you, Referee Frederick.
Thank you.
Thank you.
We are here, Your Honor.
All right. Thank you. We're just getting your file. That, of course, is extremely big. Volume 7, I believe. No, volume 8. Wasn't it on a record for the most that I have in front of me? This is the case versus Emery. Both parties are present with their respective attorneys, that being Ms. Gorsline for plaintiff mother, Mr. Khalifi for defendant father. This is a motion for entry of an order by the plaintiff. I've received various pleadings from both of you. I've received the motion and answer and a response to the answer and whatnot. And I guess what I'm tempted to do is to tell you what we need to put in an order. I think you both attorneys have kind of agreed to most of it. Isn't that correct?
I believe so.
There seems to be some question because of whether or not, if this is all about the child's sporting events. Okay, he's now in soccer or something, or track or whatnot at his school and wants to participate. And I have said that he will be allowed to participate because of the unusual situation where mother lives in Chicago. And the child goes to Chicago basically on the train where they meet in Michigan City or something like that. And he goes for his every other weekend to Chicago. But it has been stated to me, and I guess nobody's really disagreed with it, that some of his sporting events that he's in are going to interfere with Miss Emery's weekend parenting time. So far, I'm right, aren't I? To both counsel?
Yes.
Stop if you think I'm wrong. Yeah.
Sounds right.
So my order from the last time we were here, and I read through some of it, and maybe it wasn't the most, wasn't the greatest statements that I've ever put on the record. My intent is that the young man will be able to participate in his sporting events. Some of those is my understanding that some of them will occur on weekends. And as a result, will interfere with Miss Emery's parenting time that she has every other weekend. Basically, she gets Friday evenings till Sunday evenings every other weekend. And it's my intent that the boy will be able to participate in his events, even if it interferes with Miss Emery's parenting time. The parties have kind of reached an agreement that says during this school year, when he's in those events and can't be there on from Friday night to Saturday, that they will instead make sure that he gets there Saturday at around 6:30 and comes back at 6:30 the next day. The offer was made to basically during the week, during the time that he's involved in sporting events, that instead of every other weekend, he would get every Sunday from whatever the, 6 o'clock or whatever the train runs till 6 o'clock on Sunday. I'm still on track, I think, with what has been agreed. There was question about if he didn't have something on a weekend, then does she get the whole weekend? And what I'm trying to say is, if the season's 10 weeks, okay, and she gets 5, she'll be entitled to 5 weekends, or in other words, 10 10 days during that period of time. She'll get those 10 days, either in a single day at a time, or if she has a weekend, then he has nothing on it. She'll still get the 10 days, but not necessarily every Saturday night and a couple of her full weekends. She'll still get her 10 nights. That's what I intended to put out there. If you wish to agree on something else, that's fine. Then somehow I'm being asked to be a train conductor or something and figure out which train the child's going to ride on. And I think that's, I went through a lot of schooling, including college and law school and 43 years, but I'm not really good at the train schedule and stuff like that. So can the parties agree on where and when to meet? There is a clear agreement on Friday nights, right?
Yes.
Friday night?
Friday, yeah, when it's every other weekend, there's a train schedule that you guys have figured out, right?
Oh, are you talking like during non-sport seasons?
Yeah. I mean,
Yeah, I think that they meet on Friday in the evening, basically, and then on Sunday they meet earlier than that.
yeah, I understand. I'm not changing any of that. I'm just trying to change the when she gets to have these kind of makeup days for her missing that. All right. And so what is everybody asking me to do? Some train from Michigan City at some city and that and this and that. And I mean, why can't we agree on that exchange?
Your Honor, I believe the parties have.
Oh,
I believe that they've agreed that on weekdays, so for instance, regular parenting time Friday nights at the Carroll station, and then on weekends or holidays at the 11th Street.
yes. Is that correct, Mr. Khalifi? I mean, I'm not changing any of that. That isn't even up for change. All I'm looking for is when he is in sports and she has to miss her Saturday,
right,
but gets the Sunday. Is there any reason that we don't use the same stations then?
No.
I think that it could be. I think that, give me 1 second, please. Maybe I can clarify that.
Your Honor, it'd be the same trains. They're only 3 minutes apart.
Hold on.
But the 11th Street is safer because it's near a mall and stores and churches, but it's not available during the weekday. Okay.
It's not available during weekends?
So they just changed the schedule May 14th after our hearing. And so now the only stop we can use on weekdays is the Carroll station. That's why we're doing Carroll on weekdays.
What do you mean weekdays? None of this is going on weekdays. All of this is
on Friday. That Friday.
Friday.
I meant Friday. Yeah, right. Friday, Carroll's the only one available. But Saturday, and it's an unmanned station, and Michigan City, I don't know if you know, is a high prison population, and it's unmanned. But on the weekends, we can use 11th Street at the same time. It's 3 minutes apart, and be near that mall. So that
Street now.
Yes, we will be. No, we were using it originally, but it was construction the last 3 years. It's open again.
All right, Mr. Khalifi, 11th Street. I mean, this is not going to come into play very often because, quite frankly, we got summer coming up and he's in soccer and track. So I need to.
I'm going to do my best here. I'm making sure I'm right about this before I start speaking.
Well, I've got a lot of motions here, so I don't mean to rush you, but quite frankly, a ton of people waiting here. We use it on a regular weekend, on a Friday to Sunday. We use
Friday we can use Carroll. That's the only one available with the new schedule. And Saturday and Sunday, 11th Street, which is 3 minutes apart.
Then and is that used for both pickup and drop off on Saturday and Sunday when that?
Yes, it would be 11th Street, right.
11th Street, Saturday and Sunday. When
that
comes into play.
Correct, for drop off and pickup. And when Friday comes in, we have to use a Carroll on Friday because that's the only stop that has.
And you use 11th Street for the drop off. Is that correct?
Yes.
Yep,
Sounds pretty
3
simple
minutes.
to me.
Yeah, it is.
Mr. Khalifi,
Well, I was not able to follow what she was saying while also looking at the train schedule. I can tell you this, that the goal, if you'll allow me to recap the agreements, my understanding is that the parties are swapping Mother's Day and Father's Day every year. Is that accurate?
Yes.
Okay. The parties are saying that holidays supersede the sports schedule. Is that right?
Just the Mother's Day and Father's Day.
No, there's
Mother's
other
Day
holidays
won't
all
even
during
come
the
into
sports
play.
season.
Yeah.
Oh, I'm sorry. Holidays. Yes. I'm sorry. Yes. They're only
Okay.
switching.
Okay, so I am covering ground, Your Honor. I'm trying here. And then with sports season, and then you've got non-sports season weekends. I think we're gonna have to leave the non-sports season weekends maybe to the side for right now.
I'm
because-
not even modifying that.
I'm
Nobody
addressing
ever
that.
questioned, and that just stays the same as well as the pickups, the times and everything. That was never before me.
Correct, and I'm just acknowledging it. And then when it comes to the sports seasons, we're saying that if it appears that the court is saying that overall during a sports season, each party should end up with roughly the same amount of time,
Yes.
right? Okay, and then the proposal we put forth is that we would bifurcate every weekend, and you're saying that generally that's fine if there's a weekend during a sports season where there's no event and it falls on either Matt's weekend or Melissa's weekend, it's possible that they would not bifurcate that weekend. Is that what the court is saying?
All I'm dealing with here is Miss Emery, quite honestly, all right? She gets those number of parenting time days. Over a 10-week, she will have 10 days, all right?
Yep.
And if she gets the weekend that belongs to her and he's not doing it on there, then the next weekend she won't have to just get Sunday or Saturday night to Sunday. It's
Okay.
really a simple calculation.
And I think that
or if you wish to, you can just agree that for the sports season, she'll have every Saturday to Sunday. That's between you and Miss Gorsline and that kind of stuff. But it's not to increase or decrease her parenting time. The only thing that's left is on Friday nights, there's a drop off is at Carroll Street, as I understand, and the pickup is at 11th Street on the regular weekends. Instead of this, if there is a bifurcated, if you want to call it, if she is getting only Saturday not overnight to Sunday, both the drop off and the pickup will be at 11th Street. End of that.
Yes. And I think then that the way that it would work probably so that there is an additional motivation, which is to avoid discussion on these things if possible. And so it's just set up.
It is. So I just said it.
Okay.
If it's Saturday to Sunday, the drop off and pickup are at 11th Street. If it's the Friday through Sunday, the drop off is at Carroll Street and the pickup is at 11th Street. All right.
Yes.
Yes.
All right. Good luck, everybody. Send me
Thank
an
you.
order that says that and give it, Mr. Khalifi, if you're drafting it, make sure it goes through Ms. Gorsline. And if you guys are having problems with it, call the court. I'll have a quick case conference because this is going on just way too long.
Thank
Right.
you.
My law degree is gone for naught at this point because I'm picking trains. Good luck, everybody. Have a good weekend. Thank you very much. You have ma'am, I need you to be on camera also.
Okay.
Camera on. Sir, I hate to tell you, but you're in court and you can't wear a hat. Thank you. All right, we're here in the matter of Elmblad versus Vandermolen. This is a request from the father, a motion that's been filed for a temporary order in this case. This case has just started and the court will fashion a temporary, I want everybody to know it's a temporary order. The father says that they're two kids, I think a 4-year-old and a 2-year-old. Father states that the mom has disappeared from the kids for weeks at a time. She tried to pick up the kids once while she was intoxicated, doesn't properly care for Aiden's type 1 diabetes, and he wants sole, legal, and physical and supervised parenting time from mom. There is also a CPS statement attached to this. I'm not sure what, I mean, it's just something that says medical reason for concerned medical neglect, proactive contact FOC or for custody and parenting time ASAP is what they have told apparently the plaintiff. Ma'am, you didn't file an answer at all. What's your position on this?
What do you mean by file an answer? I didn't get any paperwork or anything on this case.
Sir, did you serve her?
The daycare did.
What do you mean the daycare? You dropped it off at daycare?
Yeah, one of the owner of the daycare served her the paper.
When?
It was in April. I don't have an exact date.
Ma'am, you got a copy of it back in April?
Yes, but I didn't know I was supposed to send in anything.
Well, he's making allegations. What do you have to say about it?
Almost all of those allegations are not true. It's more so he said, she said stuff.
So what are you seeking in a temporary order? I mean, he at least tells me. I don't know what you're asking for. When was the last time you saw the kids?
Almost a month ago, because he implemented having supervised visitation, and I'm also homeless at the moment.
Well, if you're homeless, you can't much have parenting time unless it is supervised somewhere. I mean, you're not giving me anything that I'm supposed to do. At this point, if you're homeless and you don't see the kids and this kind of stuff, and it's been over a month, I'll let you see them. But at this point, at least for a temporary order, it would seem that it would be appropriate to give him physical custody. We'll do joint legal, at least right now. And unless you guys can't work together, and for major decisions for the children, if you can't, you might have to come back and give somebody sole legal. But this is just a temporary order. All right, no matter what, it's a temporary order. Kids will reside with the father. The mother will have parenting time. Sir, what do you think is? I know you want supervised. Who's an appropriate supervisor?
I believe her mom and sister would be fine, but no overnights. Maybe my mom.
Ma'am?
I can agree with that.
All right, so we got to come up with some time. She's got to be able to see the kids.
No, I agree.
Even if it's ma'am, your mother or your sister or Jordan's mother can act. I mean, who do you want to be supervisor?
Either my mom or my sister.
Can you take the kids to your mom or sister's home?
No, not necessarily.
Well, then where are you going to visit with them?
More so pick up my mom and then the kids and go somewhere and do something.
All right. Then what, on a night a week or when?
I'd like to at least bare minimum 3 days a week.
3 days a week?
Mm-hmm.
Or where are you going to go for 3 days a week?
It likely would only be a few hours.
All right. The kids aren't in school. I mean, Aiden isn't in school yet, is he? And even if he is, he's done right now, probably. Mr. Elmblad?
He is going to be starting.
Yeah, September or whatever. All right. So what kind of time? Give me a time or two that you think is appropriate. I don't know your work schedule. I don't know, ma'am, are you working?
No, not at the moment, but I'm like seeking work, so I don't know what I'll be working exactly.
I mean, you want to do every, I don't know, Saturday noon to 2? Noon to
yeah,
3?
I can do that.
Something like that?
Mm-hmm.
Sir?
The weekends are kind of rough for me, but I mean, I can try to make it work as best.
Why are they rough for you?
I have to work like 6 days a week right now.
Yeah, but who watches the kids?
Either the daycare or her mom or some family members. I'm just kind of winging it right now.
All right. Well, I mean, if you're at work, it doesn't hurt if she has the kids from noon till 3 on Saturday. On however, must be supervised by your mother or your sister. What's your mother's name?
Miranda.
Miranda?
Yeah.
What's her last name?
Ates, Ates.
Ates. Or your sister?
Alexandria.
Her last name?
Hansma, Hansema.
Hanesma?
Yeah.
Must be supervised. That means they have to be with you at all times. If I find out they're not, you're going to lose your parenting time.
Okay.
All right. Every Saturday from noon to 3 p.m. We'll do another day during the week. What about Wednesday or something?
That works.
Same time, noon to 3?
Yeah, that'd be fine.
Every Wednesday, noon to 3. That'll be it for now. We'll send it. And then why don't I send it to the friend of the court for their review for custody, parenting time, child support, and everything. Any objection to that by either of you?
Your Honor, on Wednesdays, they are about to be back in childcare, so she would have to pick them up from childcare, and then I don't get home until about 5 o'clock, so it would have to be an extended time.
Well, are you all right with that? From noon till 5 on Wednesdays?
I mean, I don't really know where I'd bring them for 5 hours.
Can she return them to daycare, sir?
I'm not completely sure. I don't want to tell you yes and me be wrong.
Is there a different day, a Tuesday or Thursday that's better?
Could we possibly do the weekday in the evenings?
5 o'clock in the evening till 8?
Yep, that's fine.
Ma'am, Wednesday, 5 o'clock p.m. till 8 o'clock p.m.?
Yeah, that's fine.
All right. And then I'm also going to send this to the friend of the court for them to look at custody, child support, all those issues. I'm sure you don't have money to pay the $150 for it. So I'll waive your fee, Miss Vandermolen. It looks like father might, but if I'm waiving yours, I guess it'd only be fair to waive his fee also.
Thank you.
So we will waive both fees. So the order will say that dad's to have temporary physical custody, mom is to have and dad to have joint legal. Parenting time for mother will be every Saturday from noon till 3 and every Wednesday evening from 5 p.m. till 8. Those parenting times will be supervised by Miranda or Alexandria. And I'm serious about that. Do not say, mom, nobody will find out. I'll take the kids for a couple hours. I'm serious. You'd be surprised how easy it is to find out. If it's found that they're just gone or you're just taking off with them, I'm going to suspend your parenting time. And I don't want to do that. Your kids need to see you. All right.
Okay.
Understood by everybody?
Yep.
Good luck. I'm sure we'll see you back for a final order at some time in the future.
Thank you.
Anything else? Thank you both very much. We'll get an order out to you. Okay.
All right, thank you.
Thank you. We're adjourned. Oh, all right. Hello, everybody out there. YouTube land, Missy, Cheryl, Sharon. I should know more of them, but good morning to you. We're going to be here for a while, so.
Yes, I've been here.
We are here in the case of Hood versus Hurd, and both parties are present with their respective attorneys. Mr. Reens representing the plaintiff mother, Mr. Haslam representing Justin, the defendant. This is a motion filed by the defendant regarding parenting time. He wants to increase his parenting time and other matters. I've read both of your briefs and the response, but I understand that most of this, Mr. Reens, you have agreed to the request. Is that correct? I mean, one of the requests was there's a vacation that they want to make sure that it occurs, if you will, and you have no problem with that. Is that correct?
Correct, Your Honor.
Mr. Haslam, I think that takes care of one of yours, right?
It does. The specific vacation days and times for 2024 are set forth in the motion.
Secondly, there is a request for a holiday parenting time schedule. I've reviewed it. I have no problem. I have no reason not to order the Ottawa County parenting time schedule. It's used frequently, and I know Mr. Haslam, you've even asked for it on cases in front of me before. I'm making nothing other than it's an appropriate schedule, and Mr. Reams, you have no problem with that?
In relation to that, just this morning, sent that to Mr. Haslam this morning. That schedule calls for a bunch of start times at 6 p.m. These folks actually do exchanges at 3 p.m. And so I suggested that those parenting times start at 3 rather than 6, which actually gives these people more parenting time.
It gives these people, meaning Mr. Hood.
Yeah. And that has a return time at 8 rather than 9, just because the kids are a little bit young still.
Mr. Haslam, with those changes, do you have any problem with the Ottawa County schedule?
Well, I think the one point of confusion, I think, Your Honor, is that there was an update to the Ottawa County parenting schedule perhaps the middle of last winter, effective as of the end of January of 2023. And what that did was changed how the Christmas holidays are allocated. And I would suggest to the court, our exhibit 1 pretty much tracks that Ottawa County holiday parenting time schedule, except for the sake of having some level of family unity with my client's significant other. It does specifically assign Christmas Eve and Christmas Day holidays. So there also is some, because I took an opportunity last night to look at the Ottawa County, the most recent 2023 iteration. There's some language missing from that in what council has proposed. We would ask that the court adopt our exhibit 1 as the holiday schedule. 1, it closely tracks the most important components. We have no objection to that earlier exchange time at 3 o'clock. I got that this morning, sent it on to my client.
What's your thought on this?
Could I just need to finish one thing, Your Honor, that is.
Just let me ask, because I don't know how far I got to fight with this. Mr. Reams, what is your thought about that?
Your Honor, the Exhibit 1 to the motion does not track the Ottawa County policy. It just doesn't.
Well, what's your objection to Exhibit 1?
My objection is that it reverses the odd even, that it doesn't track the policy, and it is in no sense consistent with what you would want as a standard schedule. This is
the schedule. Other thing is, I'm going to say is, do you have the latest one from Ottawa County? Mr. Haslam is saying the one you sent in is not the latest one from Ottawa County.
It was my understanding that it is. If I'm wrong, I'm wrong. But that's what I had in my system as the most recent version.
Can you, Mr. Haslam, can you forward anything that's different to him? Because I intend to follow the Ottawa County.
Well, I can, Your Honor, but I need to point out that one of the issues here with respect to coordinating between these significant others so they can have their children on the same holidays is the way Mr. Reams has proposed it. What we are asking for is that Dad have even numbered years spring breaks, and that's important. You know, you saw what we.
That's fine. That's fine. I don't really care. Once we start this, it's just a continuing thing. All right. And if it works better for to reverse the mother and the father having the odd and even, that's fine. Mr. Reams, you can argue against it, but it's just a start date. Okay. And obviously this time you're saying that he would get the even numbered spring break, if you will, and everything can flow from them. Correct.
That's correct. And what that results in, obviously, is that results in mom having, the 2025 spring break, and we don't mind because it sets everything up the way it
you have, Mr. Reams, do you have an objection with it? Us starting that time frame, if you will, and everything goes from there, so we can figure it out. It just rotates.
Your Honor, that's not what my client had authorized me to agree to. So at this stage, I do object to it.
Well, then.
And if Mr. Hood finds that funny, that's great.
That's what
but I'm not really sure what's funny about that.
That's what I'm going to order. It's my understanding that Mr. Hood has a family, if you will, with his significant other, and he's trying to kind of track it so that those kids can be together. That's appropriate. I will allow spring break next year for Miss Hood, and everything works off of that. All right.
Yeah, we have no objection to that, Your Honor. The other, probably one of the other issues that Mr. Reens is objecting to, I'm not certain, is the 2 weeks of non-consecutive parenting time beginning next summer for both parties with notification, and the language regarding, whose choices get preference if there's a conflict. That is under extended summer parenting time on Exhibit 1.
Which is not holiday parenting time.
Correct. It is separate parenting time.
Correct.
Aren't each party allowed 2 weeks, including their weekends, of summer parenting time when the kids are off school? And again, I don't care who gets this. I mean, this year we're already past the May 1 date.
That's correct.
But.
And Your Honor, I mean, that doesn't exist in the current order. So that's adding summer parenting time. So the court will remember that where we are now is that neither party has extended parenting time in the summer. Mr. Hood's actions previously in this matter have precluded.
I'm well aware of that. You don't ever have to remind me of that. All right. I understand. I don't think that it's inappropriate that each party gets 2 weeks in the summer. I just don't. I think that's probably appropriate. And it does add, in effect, 10 overnights to Mr. Hood. All right. But each party will have it. Mr. Haslam, you are to send Mr. Reens by Wednesday at the latest of next week what the 2 weeks are that he chooses. And Miss Hood, the same thing for you. You get 2 weeks of uninterrupted. And you need to get to Mr. Reens and ask for those 2 weeks that you want. All right. And
Your Honor, just so we're clear, he's already chosen 1 week.
Okay.
Yeah, I think we have a ruling on that.
That's fine. You've agreed to that and didn't have a problem with it. So one other week, and she gets the 2 weeks too. Hopefully those don't interfere with each other. If they do, between the two councils, and from now on, she gets the odd years if they conflict, and he gets the even years. That's how we're doing stuff right now. All right. And both council know what I'm talking about on that, right?
Yes, Your Honor.
The other matter, there's another matter that came up that said about a therapist, and that the recommendation is that each party alternates taking the children to the therapist. Mr. Reens, in your pleadings, you say you don't have a problem with it.
I don't have a problem with it. The problem that I do have is that it would go in an order. I don't think that the court should be directing how the therapist structures this thing.
I'm not going to do anything with the therapist. The therapist is going to decide when the therapy is, but each party will alternate taking them. Okay.
Again, Your Honor, if what we're doing is we're going in conjunction with what the therapist recommends. If you put it in an order and she recommends something else, Mr. Hood will defy that recommendation because of it's in an order.
It is right now, the parties will alternate taking the children to therapy. All right. I don't know when it will occur. I don't know how often it will occur. I think from the looks of it, not all the kids go at one time to a therapist. If the youngest child is scheduled for Monday and Miss Hood takes, and then the oldest child is to go, I don't know, Thursday, Mr. Hood will take. It's just who takes them and gets them from the therapist.
We might even be able to completely short circuit an argument about this, Your Honor. We have no problem with the parties abiding by whatever Ms. Parolini recommends or asks for in terms of the parties bringing the children on an alternating one basis or an alternating group basis. And if she changes her mind, she changes her mind, and Mr. Hood will abide by that request of hers.
Is that what you're asking for, Mr. Reens?
No, it's not. None of this should be in an order. No therapist recommendations should be in an order. That is the purview of the therapist. And if we go down this road, every time this happens, we're going to be in court again. And it's the last thing any of us want to do.
I don't totally understand it's just who transports the kids to the therapist. Nothing.
Right, and that's based upon the recommendation of the therapist. The therapist is going to make another recommendation, and then we're going to go down that rabbit hole.
But I don't, all I'm dealing with is transportation, nothing more. Nothing more. All right.
Mr. Your Honor, can I get I need a point of clarification. I mean, I think you said preference for the weeks during the summer would be even years father and odd years mother. What we had requested, and I think it gives, I mean, and it gives some advantage to the plaintiff here, is that father's choices, if there's a conflict, goes in odd years and mom's in even years. And we're happy to work that out for this year. And if there's a conflict, give her the preference.
I just said it's going to be odd years to her, even years to him. That I'm just, it's a boom.
Well, that creates a bit of a,
doesn't even create a problem until that. I mean, no, it doesn't create a problem. That's what it's going to be. All right. I mean, you only are getting 4 weeks out of 10 in the summer. Chances are they aren't even going to go against each other. All right. And if the therapist, Mr. Reams, from your standpoint, if the therapist says, wait a minute, we shouldn't have this going back and forth with who's transporting, only transportation. That's all it is. If they say, no, this isn't working out well, and you guys can't deal with it, I'll see you back here. It's not like I haven't seen you regularly anyhow, but end of that. So the therapist is done. The Ottawa County is done. Vacation is agreed upon. He gets 1 more week that he's going to try and figure out. That leaves the big one of parenting time. Mr. Haslam, you've requested some 75 additional overnights, which clearly by all the courts says that's a change of custody, it affects an established custodial environment, and you must meet Vadvarka to do that. Vadvarka isn't even a shadow in your motion. There's no proper cause or change of circumstance that I can find, even in the heading or anything.
Well, I think the court can take into account what certainly appears to be from Exhibit 4. It
isn't an agreement.
Well, Your Honor,
if I take into that every time there's negotiations and stuff like that, I'll never. It'll be never ending, and you know I can't take in negotiations as to what it possibly is or isn't. There is no Vadvarka present, and they do not agree to it. Therefore, you must meet Vadvarka to even get a hearing. And I'm not going to order it on a Friday morning because Vadvarka is not met. I've given him actually an extra 10 days already. And you're asking for an additional 75. Mr. Reams, I don't expect you have much to say on this other than from your pleadings, you clearly agree. And I pointed out that Vadvarka is not met. Correct?
Understood, Your Honor, and I agree.
So I cannot order additional parenting time as requested. Vadvarka is not met, and therefore I will deny you want every Wednesday overnight and every other Sunday overnight. You do not meet the standard for the court to review that. Is there anything else?
I don't believe so at this time, Your Honor.
Not from us, Your Honor.
All right. Good luck putting an order together. Mr. Haslam, as your motion, you'll be responsible to draft it and send it through Mr. Reams.
All right, Your Honor, very well.
Thank you. Good luck, everybody. Have a good day.
Thank you, you too.
As well.
iPhone, what's your name, please? You're on mute.
Casey Briggs.
Casey. We'll put you back in and bring you back in a minute.
Okay.
Sir, can you hear me? Jesus. Samsung phone.
Yep.
What's your name, please?
I'm Ollie Woods.
Miss, is it Wood?
Woods.
Ollie Woods.
Yes.
All right.
We'll rename you and put you back in the waiting room. We'll get to you as soon as we can. I've got a lot of them today.
Okay. Thank you.
Yep. So you message these people and they just don't respond? Google Pixel 6, you're identified. What's your name?
Billy Charleston.
Mr. Charleston?
Billy Charles.
Yes.
I got it.
All right. We'll put you in the waiting room. I got a lot of people on today. I'll get through you as quick as I can.
Okay, thank you.
Thank you. Sir, what's your name? Did he just? Oh, bring him back.
I was trying to review.
Can you hear me?
I can now.
What's your name, please?
Lawrence Torres Chavez the third.
Mr. Chavez. You have him. What's the name of your case? Who's the other one on it?
Dilly, Dilley. Well, it's Hines. She's married now.
Emily Dilly and Lawrence number 6. Okay.
Yes, sir.
Is Emily on? We haven't seen her, so I'm going to put you back in waiting room. I've got a lot of these today. I'm trying to get to everybody as fast as I can.
I understand, sir.
Thank you, Mr. No, I know these people, so I don't. Mr. Brayford, can you hear me? You're on mute.
I can hear you. Yes.
All right, I need you to check into Judge Hillary's courtroom because he is waiting for you. Okay.
Okay. I'm sorry. I was confused. I got 3 links today.
Yeah. No, you got to come back to me eventually. But Judge Hillary has something. I don't know how this worked out, but they contacted us and asked if you could appear in their courtroom first. Okay.
Okay. Thank you. I will handle that.
Because Kayla's up there. Okay.
Okay. Thank you.
We'll
I'll
see
handle
you back
that.
a little later. All right.
Yep.
Thank you.
Bye.
Do one more time. Bring it in. And if
I got one. There's one more.
can you hear me? No.
And then I'm gonna ask this.
You have another iPhone person?
Yeah.
Bring them all in so we can identify them. Sir, can you tell me your name?
Jesus Cruz.
Jesus Cruz. You're on case with, who's the other party?
Gitani Valadez.
Yeah, I have.
All right, we're gonna rename you. I've got a lot of hearings today. I'll get to you as quick as I can.
Excuse me, sir. I only speak English too much, so I need an interpreter.
Did you ask for one?
I don't have it.
All right. Well, you're back in the waiting room. We'll bring you back later. We'll see if we can get an interpreter.
Thank you, sir.
Thank you. Morning, Miss Rummel.
Good morning. I've had no contact from Mr. Fox except for an answer that he filed.
All right, well, let me call the case here.
Okay.
So, yes, it's McSawby versus Fox. We have Miss McSawby here. We have Miss Rummel from the prosecutor's office. This was noticed for entry of a judgment of support, as Miss Rummel had just said, but she's had no cooperation apparently from Mr. Fox whatsoever throughout the pendency of this case, other than what, an answer?
Correct.
And but he's not followed up. You've given him appropriate notice of this hearing, as well as tried to have contact with them. This is the date and time set for entry of a judgment of support. You have 0 overnights. There's 3 kids involved. There's 0 overnights apparently with Mr. Fox. Mom has actual income at $18.50 an hour times 40 hours. Unusually, ma'am, yeah?
Yeah.
Okay. The father, I've gone through the potential income factors for him, but in essence, the prosecutors indicated that he receives Native American payments and has not disclosed or given you any information as to what those are. Ms. McSawby, are you aware that he gets payments from the Native Americans?
Yes.
Do you know how much he gets?
I don't know how much exactly, no.
All right, well, the
I
prosecutor.
know it's around $1,000 every 2 weeks.
Okay, that's 26,000 or something. The prosecutors imputed him at 55,000 a year because of research that she had done, indicating that I can get to it here because he has no work history, and he's a member of the Saginaw Band of Chippewas. Research suggests that annual per capita payments are between $60,000 and $72,000 a year for that.
Yeah, that seems correct. The $1,000 would be his take home after
all right.
all taxes and everything he gets taken out.
So he probably gets at least $1,000 a week.
I think it might be like $1,500 to $2,000 before taxes and.
Right. Well, due to his lack of cooperation and everything, and the fact that the prosecutor has imputed him at less than what she shows are approximate payments of $60,000 to $72,000 a year, I find that it is appropriate. The other factors in here don't really come into play nearly as much. He lives in Isabella County. Employment is, but we're really not doing it based upon his employment as much as just him receiving regular payments and not working. And as I say, he has not cooperated, given us any information, nor has he allowed the prosecutor to contact the appropriate authorities to find out how much he does make. It appears, even with Ms. McSawby's statements, that it is reasonable to believe that $55,000 is a correct amount of gross income per year, not take home. And as such, I believe the amount that is indicated in here, which is $1,800 for 3 kids, is appropriate based on those incomes. Ms. Rummelt, I took all your glory from you and said everything that you said in here. Is there anything you want to add?
Just one thing, Your Honor. The parties are legally married. Ms. McSawby has her youngest child, parties seem to agree, is not the product of her marriage. We filed a complaint back in December of 2023, naming only 2 children. Ms. McSawby filed a ROPA motion for the 3rd child, but because that child was not a part of the original complaint, the court lacked jurisdiction to grant her ROPA motion. We then filed an amended complaint with all 3 children. I explained to Mrs. McSawby she needed to renotice that ROPA motion for her 3rd child. She has not done so. So she can do that post-judgment still. I do wonder whether, how difficult it's going to be to get Mr. Fox to participate in genetic testing based on his behavior thus far. So I'd request that the order enter for 3 children as some incentive for him to comply with genetic testing if it is ultimately ordered. Thank you.
All right, Ms. McSawby, did you understand what was said? You can renotice your motion to find that your youngest child is not part of his, but as of now, he is still the legal father, and he will pay child support for that child unless he is found to be not the father. If you file a motion, if it's with me, I mean, I'm clearly going to order DNA testing, which if you file that motion, and if he doesn't cooperate in that, there are 2 ways you can do it. Either he cooperates and gives you DNA, or if you know who the actual father is, and if they give you DNA that proves that he is the father, I would certainly hear it then also. So
Yeah, sorry to interrupt you, but that's what I originally wanted to do, is just test my boyfriend, who is the father and does take care of our baby, because I know William he'll try to prolong it and try to fight me for as long as he can. And if he knows he has to go take DNA for the baby and that'll stop child support, then that is what he will do.
it might be because he's going to be paying for that child at $1,800 a month. He's got to pay you in child support. Okay. And I'd imagine we will put in something so that we can try and garnish it basically from his payments. The best we can. I don't know how that works, but and if he's not going to cooperate with you, I'm just telling you, if you refile that motion or renotice that motion, that ROPA motion, the one to make him the non-father.
Yeah.
If it comes to me, I probably won't even make you come in. I'll probably just issue an order for DNA testing. And if you can't get cooperation and you really want Mr. Fox to not be the father, I'm giving you this suggestion now that you have the actual father submit DNA, and you come back and that's when you come back and say, we have DNA that shows that this man is the father, Mr. Fox is not. And then I'll ask you a few questions and probably rule that child is not a product, is born out of wedlock. Okay. And then you can go about everything you need to do, like signing an affidavit of parentage or something to make that man the father.
Okay.
Right. So, but as of now, he's going to pay child support on all 3.
Okay.
All right. Ms. Rummelt, when you send me that order, I'll sign it. Thank you.
All right. Thank you very much.
Good luck, everybody. Thank you, ma'am.
Thank you.
As is Miss Ludwig. Both of you can hear me all right? Mr. Ludwig raised his hand. Ms. Ludwig, can you hear me? All right. We're hearing Ludwig v. Ludwig. Both parties are present with their respective attorneys. Ms. Bryan for plaintiff mother, Ms. Van Tol for defendant father. This is basically a discovery motion seeking discovery of certain videos and requests for further videos. I've read both of your briefs and whatnot. What I understand, I mean, clearly there's liberal discovery. And the request appears to be, Ms. Bryan, that there were some videos from in his house that were provided in your request for discovery. Some of them didn't have audio. Some of them were missing from a downstairs bedroom, things like that. And those were listed in, I think they're paragraph 15, 14, and 15 in your request. Is that what you want the balance of that?
Yes, Your Honor, and you're correct that I listed what was not there because it just seems odd to us that he produced some but not all. And I wanted to remind the court, do you want me to keep going?
As long as you're not going to remind me for too long.
Okay, all right, I won't. Remind the court that we do have the court rule that is fairly new, but I'm sure that Ms. Van Tol has already advised her client that there is in our rules a duty to preserve the electronic evidence. And there's a consequence, which is in case law, if people don't preserve it, or if in this case they altered it, which is what Mr. Ludwig did when he removed the video or the audio to some of the video, which we think was actually, intentional and designed for other reasons. But that's an issue we can get to if we ever have a trial on this custody case. I've received Ms. Ludwig's answer, which is that, well, they don't have it anymore. And I suppose that's an appropriate answer if it's truthful, but I have a right to rely on that. And there are consequences to that when we have a trial.
What I'm going to suggest is that if they don't have those that are available, those from 14 and 15, you know what I'm in her brief, don't you, Ms. Van Tol, paragraphs 14 and 15?
I do.
All I would like really is for, if your client doesn't have, I can't reproduce something that's gone or that he doesn't have. All right. So all I would ask is that you provide them maybe a affidavit or a sworn statement, something that your client says that they're not available or that he doesn't have them or whatever. All right. That'll fulfill everything. I can't make him produce something he doesn't have. All right.
If you're asking if I can do that, absolutely, I can do that. And I'm happy to explain how the system works, but I'll get to that.
I kind of read about this system and stuff like that, and I'm about as versed in electronic cameras as I am in Zoom, which is not very right. But she's entitled to know that if you say I don't have them for whatever it is, you can send it to her he can do it under oath or something, just like he's answering an interrogatory.
Yeah, that's absolutely fine.
Then we'll deal with it from there if we ever end up in trial.
Okay.
Right? I assume that would satisfy or produce them, whichever he has. Okay. But that will satisfy Ms. Bryan. And if we get to a trial, I'll have to deal with it then, what assumptions or whatever can be made by it. All right. So that ends, I think that ends the first part. All right.
The second part is actually with respect to paragraph 20. So on paragraph 20, this is a really important issue because the child, as you know, indicated that an individual by the name of Johnny to him. We indicated in the motion, and Attorney Van Tol and her client both agree that the child's counselor says, yes, something happened to this child. We're trying to uncover it. There is currently an order that says Johnny can't be around him. Child says Johnny was around him a specific weekend. Dad says, well, here's the video, but of course not all of it. Or actually, he didn't offer the video. And instead what he said, and I just received a response this morning while we were waiting for the court, that she sent a response saying she doesn't have that video. So that brings us kind of to our third issue, which is, it has to do with, again, the preservation of electronic evidence. There is a duty to preserve electronic evidence. There is a pending motion. It's been pending for almost a year. It was filed July 31 of 22. So we have a pending motion. We have a duty to preserve electronic evidence. And we're kind of tired of Mr. Ludwig being able to miraculously show edited video, sometimes without audio, sometimes with audio. So he gets to show up with his videos, ringing them over his shoulder saying, oh, I've got proof as to this. But when we go to explore a defense, he suddenly doesn't have the videos because they've been overwritten or destroyed or edited. And that seems to be the practice so far. So we are asking for an order from the court indicating that as long as he has this surveillance video up, he does have a duty to preserve it.
But he doesn't have to have it up if he doesn't want it.
He doesn't have to have it up. And frankly, you know, if he withdraws his motion to change custody, then none of this would be relevant either. So I'm not requiring an order that he has to use the video, but if he has it up and he plans to just show, you know, periodically the things that are favorable to him or that he thinks are favorable, then we have a right to look at all of the video unedited. And we can look at it depending on what issue might come up. You know, I don't know what we would be requesting going forward. Nobody can predict the future, but I don't want to have this defense by him saying, oh, I don't have it anymore, or I've edited and I've removed the audio. We can't be dealing with that. The rules are very clear with regard to his duty. The rules are also very clear as to what happens when he spoils the evidence, which is what he's already done. So I'd like to have an order saying that if he's going to have it up, he has a duty to preserve it.
But he has a duty as far as, I mean, I'm not, you're asking, if he leaves it on for the next month, okay, there's no way you're going to get a chance to look at all of those because that's in his house, all right? And I'm not going to let you go through his personal life unless you have something really specific saying, wait a minute, on May 31st at, you know, between 1 and 3, there's something that went on there, okay, and that they did something wrong. I'm not going to let you live his life, all right?
I agree, Your Honor, and I'm not asking for that. I'm not saying that we're going to have access to every single video he saves. But if he's saving video and he has that video going and there's an issue that comes up, I want the ability to say, hey, show us the video from June 15 or whatever date it might be. And he should be able to produce it at that time.
If he intends to use any video, he obviously has to give it to you ahead of time. All right. If he's not, what I mean, I don't know what you're going to ask for.
It's hard for me to predict what I might ask for too, because I don't know what's coming up in the future. But the issue is not just whether he's going to use it. The video and evidence is also available to me in the event there's a defense. The court rules specifically talk about not only what people use, but what might be relevant as to a defense. So I'm not saying I'm even going to ask for it. I don't know what's coming up between now and the time of a hearing if we have it. I may not ask for anything, but if something comes up, I would make a request for production, and then we can argue as to the extent of it, whether it's reasonable, whether it comes with audio or not. Those are all issues that would be preserved for me. But when he just dumps it out every 24 hours and then only saves what he finds to be helpful to him, that's inherently unfair.
If it comes in front, all right, Ms. Van Tol, I'll give you a moment to.
I appreciate that, Your Honor. I mean, this is an interesting system, and I was not aware of this, and I don't think my client was either. So when the CPS thing came up and the police were contacting him, what my client had to do was he had to show them the video on the app, okay? Because the app is on his phone. These videos are encrypted. You cannot simply download them onto a computer. They actually have to be recorded as you're watching them, minute by minute, second by second. It is very tedious. And so he was trying to show the police and CPS while they were there at his home and talking to him about the incident that what was said could not have happened, right? Because there was no access or ability. And so he did that. They asked him to record it. He agreed to record, like to get them the video. He had no idea how he was going to have to go about doing this. He had to contact Fight Electric, ask them exactly how he could just simply download the data. They told him he cannot just do that for safety purposes, for whatever, they don't allow it. So basically every second of that video that he has, he was manually recording. He spent over 100 hours doing that. And I understand Ms. Bryan wants to complain that she didn't get every single thing. It wasn't available. These videos rewrite themselves within the app based on the storage. It has nothing to do with my client deleting anything. It's just the way the system is set up. So what we have here is really my client spent 100 hours plus downloading video for CPS and the police. He submitted that information to Miss Bryan. What the problem was some of it was gone. Like the
I understand, but I've already ruled on that part of it. The one that are missing, quite frankly, you provide it and say, I don't have it. And you can even say why, I don't care. But that ends that. I'm talking about future recordings. Is your client using is your client still recording all the time?
He's doing the best he can. Some of the cameras aren't working right now, and so that's a problem. I don't know. It was because he switched his internet system, so it became an issue. But ultimately, yes, he is using some of those cameras. Obviously, he does not have to use these cameras, and I understand the court's ruling. My problem is that really what Miss Bryan is asking for is my client to take 24 hours a day on 5 different cameras to re-record video. He can't do that. It's not physically possible. If we just looked at the time that Cruz was in his care, that's 840 hours of recording every 2 weeks. That can't happen. He cannot physically do that. That's an impossibility. My client has only recorded snippets of information. All of the information that he's recorded relevant to this case has been provided to Miss Bryan, but it is tedious. It takes exactly the same amount of time as you're asking for to record it. So it's impossible. And honestly, it's not proportionate to the needs of this case. I think it's completely an overreach by Miss Bryan's client to be requesting this video. It's really voyeuristic, and people who come into his house should not be subjected to.
I understand that, and I understand all that as far as even in his house with his girlfriend and all that kind of stuff. I don't want Miss Ludwig hearing any of it, quite frankly, or being involved with it. He should be able to live in his own house, free and clear. I guess my thing is if he is at any time going to potentially use this video for any part of his case, he's going to have to provide it. And
that's absolutely fine.
He gets it. All right. But does he have a way? Look, I don't know. At the end of the day, can he take a thumb drive out and put a new one in and it records them?
No, it literally has to be recorded from onto his phone as he's watching it. And then he has to save it to a Google Drive. And again, this takes literally 24 hours of a 24-hour video, save it to a Google Drive. Then he has to put it on a flash drive. And that's what we provided to Miss Bryan. It is cumbersome and impossible.
Just a few comments here. The frustration from our perspective, Your Honor, is that he has a conversation with a child. It's favorable to him. So he quickly records it, and he might even send that to us. But what about the conversations that he didn't send to us? That's the problem.
Difference in that in any case that I ever hear is that, or any text message I get that's favorable, and then they say I don't have the rest of it and stuff like that. That comes up to me to figure out whether or not I should even accept it. Because yeah, I'm going to tell you right now, Ms. Van Tol, if he's going to pull little snippets out here and there and use it for his benefit, you're going to face the real probability that he's not going to be able to use it at all because we don't have any of the other information around it. I'm not going to let him pull out 3 minutes from a conversation today and get rid of all the rest, because if he's spending that much time to record favorable stuff, then he's going to have to record it all.
Well, Your Honor, the same goes for Miss Ludwig, who's produced several little audio snippets. I mean, she has nothing. She's not producing these kind of videos and Snapchat or snapshots of her life with Cruz.
She doesn't have video equipment inside her home.
I'm telling you right now, this is what I'm finding. If your client is going to pull out snippets on any given day of things that are favorable to him, then I guess that day should be totally preserved. All right. If he's not going to use any of this stuff, I don't want Miss Ludwig having any insight into his home. The people who are there, he gets to live without somebody looking at it. Okay. Including me. All right. Because in the end, I'd probably have to look at some of it to find if it's even appropriate or something. I'm not going to spend time looking at him. He can live in his house the way he wants to, okay? He can walk around naked if he wants to, and I'm not going to look at it, all right? Because that's what people do in their house, and I'm not going to make him responsible to turn that kind of stuff over. But if he intends to use this stuff, if he intends to use it to prevent burglars from coming in and stuff like that, that's fine, all right? But if he's going to use it for his case, then he's not either going to be able to use it, or he's going to have to provide a much broader than the 1 minute conversation with somebody who says, hey, Johnny wasn't here today. Oh no, Johnny wasn't here today. Okay, so see, I prove it through that. That's all I'm saying.
No, and I understand, Your Honor. And honestly, really, the biggest issues are really protection at this point. I didn't really want him to have to shut off the cameras given what has been transpiring in this case. But, you know, obviously, if he needed to, that was going to be the result. But
and that's fine. But you understand the basics of it. You'd be arguing the same thing Ms. Bryant is right now. Is if he's going to use it for his benefit, then he's going to have to provide more than just that.
The full context. I get it. Yep.
Right. And he's going to have to put it in context.
I would also suggest, Your Honor, that if we could suggest this, that if there's an event that happens, let's say something happens on a weekend, I should be able to send an email to Attorney Van Tol advising her to save the entire video from the weekend. Not that I'm going to necessarily get the whole thing, but I want it to be preserved. If there is an event, I don't want them to say, oh, well, we just preserved Saturday, we didn't preserve Sunday. We can address later whether it comes in with the audio, whatever it might be. And I think that's fair to her client to address those concerns, but we can't predict what might be happening or what might be requested. But in this particular case, I had requested the video from April 19. I asked for that on April 30. It was still available to them to download, but they quickly just got rid of it. And that's an issue for the trial, of course, as to what that really means. But
Your Honor,
I don't know if you're going to be able to prove that he just got rid of it after you requested it from 11 days ago.
it is 600 hours of his manual recording that she's suggesting. So for 3 days, 24 hours a day, 5 cameras, that's 600 hours. That is impossible.
I'm even telling you this. Even if he's preserving it, does not unless you're telling me in order to preserve it, he has to spend an equal amount of time downloading it.
That's exactly it. Yes.
That is way beyond that's just not what the discovery rules are about. I'm not making him record the weekend and spend the next 2 days downloading it for something that I have no idea if it's even relevant. However, I've told you, if he intends to use it, or anyway, it better be in context.
Understood.
Because I'm telling you right now, I will not accept it. All
Got
right.
it. Yep.
But would the court allow, and again, I use the example of a weekend, but what if it was a more narrow time? Would the court allow me to send an email to Attorney Van Tol saying, please preserve the hours of 1 to 3 on Saturday? Not that they have to produce it, because we can address the production later, but at least it's preserved.
Your Honor,
you're gonna have to provide a lot more than just please preserve 1 till 5 on Saturday. Why does he have to preserve it? The only reason he preserves it is for possible use, okay? And you're not going to get a chance to look at it even unless you can say, we know and we have proof that, so-and-so saw Johnny going into the house on that day, all right? In which case you've got your proof already, right? You've got your witnesses and stuff like that. That's what I'm saying. This is a never-ending thing. And when you're trying to preserve somebody's privacy in their house, I'm really going to not find that appropriate. Okay.
Well, again, I'm not suggesting that they have to produce it automatically. They always have their right to say, oh, no, this was this, or we should alter and get rid of the audio. I'm not trying to take that away from them. But in fairness, the court rules require preservation of evidence. I hear the court's ruling saying, well, this is too much of a hardship for him to preserve. But it strikes me that I should be able to reserve the right in the future, if it comes up, and it may not come up, just to require him to preserve it for a limited period of time. We can address whether he has to produce it.
Ms. Bryant, you can always contact Ms. Van Tol, all right? You can always contact Ms. Van Tol and say, hey, I think, 1 till 2 o'clock on Saturday has some stuff, and Ms. Van Tol can deal with it appropriate. Okay? I'm not ordering that he has to. That'll be part of your proofs, I assume, when you come in here and say, look, we think he was there at that time. I contacted her immediately and asked for it, and they said no. I'll deal with that. That's what I'm here for. All right. I'm not saying you're going to win that argument. I'm just saying that's what I'm here for as the trier of fact, is to try and figure out what is there. I just don't want to be involved in Mr. Ludwig's personal home life. All right. And you are going to have a monstrous time to try and prove that I should look at such and such, or that, but it's really simple to me. If Mr. Ludwig is going to use it for his benefit, then I'm going to need more. If not, we'll never have a video come in other than whatever ones you got.
Well, and actually, Your Honor, I just want to reserve my right to object to that last statement, because we do intend to object to the videos because of how he already doctored them. And I know that's not for today's hearing, but I didn't want your comment to be suddenly part of a court order. But if I could restate the court's rulings for today so that I could prepare the order. The court's order is that if he wants to offer snippets or excerpts of a video as evidence, then he would have a duty to preserve a broader period of time. I'll just use vague language like that.
Yeah, the context and stuff for what it is taken in.
Okay. And then the second is that my right to request preservation in the future is still preserved, but then we'll just deal with it at that time.
We'll deal with it at that time. I mean, geez, oh, Pete, you and Samantha are two of the best attorneys that I have, and you know what you're going to do and request and what's there and not. Okay. But you also know my feeling of I'm not going to be very easy on looking at what goes on in Mr. Ludwig's house unless there's something really, really obvious. Okay.
I know, and it's never was our intent to invade privacy. It's our intent to preserve evidence that relates to the issues in this case.
Ms. Van Tol, do you agree that that's what the order should read?
Yes, I do believe that that's exactly what the court indicated.
And I think, well.
And then I'm going to provide an affidavit noting that 14 and 15 were not available.
Yeah, but those
that's
ones
right.
are, from him. That having been said, I guess, Ms. Bryan, this is your motion.
I'll draft the order.
Send it through Ms. Van Tol, because she's already agreed that that's what it is. Okay.
Absolutely.
Good luck, everybody. Thank you.
Thank you. Have a good
Everybody
week.
is present with the respective attorneys, that being Ms. Rademacher for Ms. Minor and Mr. Govic for Mr. Minor. This is a request from mother regarding parenting time, and basically wants an order to prevent father from consuming alcohol before or during the times that he is with the minor child. Pretty much states it, doesn't it, in short term?
That sums it up perfectly. Thank you.
And Mr. Govic, I read your answer, and basically you said, I have no problem with that, provided it's mutual. I don't know that there's ever been anything shown to me that Miss Minor's had an alcohol problem. Mr. Minor does have a history of it.
Well, Your Honor, any history would be priced in. It was a DUI that predated the divorce. And if we're going to get into it, I mean, my client, although she was never charged with anything, my client could testify to her hiding bottles of vodka and blacking out during the marriage. But again, we're past that. We don't see any need for a prohibition either way. But if we're going to do one, make it mutual. And if the mother doesn't have an issue with alcohol or has no alcohol dependency, then it should be a negligible sacrifice.
One of the problems with it is she has the child a lot more than dad, and for her, I mean, dad doesn't have the child that long, right?
So we have 50-50 custody, 50-50.
Oh, you do have 50-50?
Yes, sir.
However, the oldest is with me a lot more.
Well, but doesn't matter. Ms. Rademacher, why shouldn't I just do it? Takes care of everybody and just do a mutual. Who cares? And they can drink as much as they want when they don't have them.
My client has not had an alcohol issue, and this is the first I've ever heard of any patients of such. And so that's why.
Well, let me ask Ms. Minor, do you object to having a prohibition of drinking while you're around the kids?
I do not object to it. The only reason that I have not just agreed to that forthcoming is that for one, I do have the oldest a lot more than Joe because she doesn't want to go there. And he is not receiving calls from the children when I have them
I understand.
saying that they feel unsafe.
I understand. You know, I got a ton of these motions today, and what it basically says, you don't have a problem with not drinking while you're around the kids. Mr. Minor better not have a problem. We'll do a mutual order that says neither of you will drink 12 hours before or while you've got the kids. And then when you don't have the kids, you can do whatever you want. All right, that's real simple. And who will draft? Miss Rademacher, why don't you draft the order?
I will.
All right. Good
All
luck
right.
to everybody. Don't drink when you got the kids.
Yeah.
Yes, sir.
And Your Honor, you know, if it was that simple, of course I would have agreed to it, but I just want to know
It's fine.
that I don't have that history. So I'll talk to my client further about it.
I yelled at you yesterday just for being on the screen, I think, because I have so many of these motions. And had nothing to do with this. So I'm just taking a chance to yell at any attorney I can because I'm nowhere near half done. And I'm at 8:30. So have a good weekend.
Have the rest of a good morning. Thank
Take
you.
care. Bye.
Bye.
Hunter, can both of you hear me?
Yes.
All right. I note that Mr. Hunter wants to represent himself here, although Mr. Cox has been on this case. I'm just going to get him to connect. I'm going to question Mr. Hunter, but if Mr. Cox can join, we'll see him. Just keep trying to get him in. Mr. Hunter, you intend to represent yourself here?
Yes.
Or do you want Mr. Cox?
I was told that he'll be jumping on, but yeah.
He is, but we're waiting for him, and I've got so many of these, I can't wait too long. I mean, I'll let him jump on if he can.
I can email.
We'll wait a minute.
Good morning, Your Honor.
Good morning. Welcome. We've been waiting for your appearance. And actually, you know what? My clerk, it was not Tracy today, made a mistake and brought in Mr. Arnson. And I said, I know they both have the same hair, but other than that,
the same beautiful hairstyle.
Yes. All right. We're here in the matter of Hunter v. Fields. Both parties are present. Mr. Cox is here, although not going to join in the argument, I don't think, but is here. Has represented Mr. Hunter in the past and is present on the Zoom. This is a motion by the mother regarding parenting time. She also has complaints about the pickup and drop off, that they're not going well, and would like the parties to be able to communicate through something different, different ways, such as an app, which would be something like Our Family Wizard. Ma'am, in reading your motion, I don't know what, there's nothing here that I see that I should change parenting time based on. There's no real change of circumstance or anything like that. What do you?
I'm looking to change the parent time schedule based off the FOC recommendation, August 31st of 2023. With that, because of our interaction during exchanges, the increased threats and harassment by Franklin, I'm asking that it be changed to that to limit our interaction. Right now, we interact 3 to 4 times a week. Changing it to what the FOC recommended will only, our interaction will be 2 times a week, which would be drop off and pick up. And I'm asking for, just for the safety of all of us, that we change the location as well from the gas station.
And I'm probably going to grant that. You don't have to go any farther.
Okay.
I mean, look, when the parties start enough complaints and stuff like that, it works out best to have a location that is the Kentwood Police Department, say, for instance. They got cameras and they got everything, and if somebody just acts up or whatever, Mr. Hunter, you may not like it, but you know, it's also for your benefit too, so she doesn't come in, because I don't know if you of course deny that there are problems there, and she says there is. I'm not there. So at the Kentwood Police Department, they'll have cameras to show it, and if things get out of hand, you can walk right into the police department. So I'm inclined to grant the change of location to the Kentwood Police Department for pickup and drop-offs. I'll give you, Mr. Hunter, if you want to say something, that's fine, but I just think it's best for both parties.
Well, reading her motion by saying safety of both parties, to me, that sounds like I understand yes, but it sounded as if there was some kind of threat there, which
I'm not finding that there is, I'm not finding you at fault. I'm not finding her at fault or anything. I'm just saying.
I understand. Yep. I hear what you're saying.
So let's do the Kentwood Police Department for exchanges. I also don't see why, I mean, look, this is enough of a contentious situation between the two of you that I would just as soon you communicate through our family wizard. It costs you a little bit of money for it, but so that then everything is out there. It includes appointments. It includes everything that you're supposed to talk to each other about, and it prevents you, well, it doesn't prevent you from talking about stuff you're not to talk about, or calling him names or her names or whatever. It prevents you from doing it. It doesn't prevent you. It just makes it so that when you come into court, I can see it. It makes that, I think you both have joint legal and physical custody. You have legal custody. You got to have exchanges of when appointments are and all that kind of stuff. And it makes it easier when Mr. Hunter, you say, wait a minute, my child went to a doctor's appointment and I was never informed of it. And I'm supposed to be informed. It'll tell me whether you are or not. If you aren't informed, and she can say, I called them, and you're going to say, no, I didn't. And I can't figure that out. So this way makes it really simple for me to be able to determine who's at fault. So I also intend that the parties will sign up for and use the Our Family Wizard.
Okay, that sounds good.
And as far as changing the parenting time, unless you want, I mean, Mr. Hunter, you're not asking that it be changed, are you?
No.
And ma'am, I just don't have, I think that the Kentwood Police and Our Family Wizard takes care of a lot of your complaint. Really, I'm not inclined to change parenting time. There really is nothing that's presented to me other than you guys may not get along very well during the exchanges. And that's what I'm hoping to prevent with Kentwood and Our Family Wizard. So I'm going to deny the motion for a change of parenting time.
Can I add, just so I guess clarification on both ends of the boundaries of parent time. Our son is 3, he just turned 4. I allowed Franklin to give him a phone to bring to the house to communicate, but it's coming to a point where he'll call my son. My son's, if he doesn't want to answer, he won't answer, but it's coming to a point where if my son doesn't answer, he'll show up.
Well, that's not appropriate. I can tell you.
It's not true, Judge.
I understand. You don't understand what I've been telling you here today. It's so hard for me. You deny it, she says it. Then you talk about her and she denies it. And I'm sitting here looking at both of you, and I don't know what's going on. All I'm telling you is that's not appropriate to show up. And if anything, you guys share pretty much equal time?
Yes.
You know, if anything, I'm going to eliminate the other party from calling the child unless this goes better. All right.
Okay.
I'll take it away from both of you. I'm not going to take it away from one. If I take it away from one, I'll take it away from both. Figure it out. All right. I mean, he is a 3-year-old. I can't even imagine that a 3-year-old wants to talk to either of you when he's with the other person, but
I agree.
It's not true, Judge. That
too much.
He really needs.
Yeah, he needs both
the interactions.
Both decent parents who don't fight. And I'm going to tell you this right now. When you guys are fighting, that child grows up knowing that you guys don't like each other. I don't care what you say. We don't fight around him and stuff like that. I don't care. That child knows that when he goes to dad, he can't go home to mom and say, Mom, I had a great time because I know you guys don't like each other. And same with her. When he can't come to you and say, Dad, boy, did I have fun? You're not going to. And then you're going to grow a child who's going to be messed up. And I've seen so many already today that it's time that the parents grow up. I don't know who's at fault and what. I'm sure both of you play a part of it because it's never just one side.
Judge,
grow up and do that.
If I have a chance to say what.
There's nothing. I've already made my rulings. I'm not saying you're the problem.
No. What I'm hearing is that you're adhering to her complaints, but I never have an opportunity to speak about what truly I haven't seen and what had occurred. I never got the opportunity to truly say what really has been happening.
What is that going to change my ruling? Go ahead. You got
okay.
1 minute.
So communicating with my son, it is something that he will let me know what's happening if he's okay, and I'm at peace with that. There had never been any increase. The only time I had actually had he had informed me that his aunt was asleep. there was a Saturday or it was a Monday that there was a drop off, and he told me his aunt was asleep, and I said, "What do you mean?" He fell asleep immediately after he comes in. Normally, when dropping him off to her parenting time,
what's the point of this?
I'm getting to the point, Judge.
Well,
he gets adequate. Normally, when he gets, what I'm saying is, he comes in extremely tired. When it's her parenting time, I make sure that he's ready to go. He sleeps in properly and he goes out. He came in to let me know that his aunt was asleep. I said, "What do you mean by that?" I asked him, "What happened? Where's your mother?" He said, "She's coming to pick him." He said she's coming to pick him up in the morning. I recognize that what is happening is she would have been breaching the order that was in place to say that there's a third party more than 4 hours. So he was not where he's supposed to be. The second thing he said, he started acting out, and he started presenting himself in a way and calling the name Jeff. He said, "No, Jeff,
Why don't you call your attorney about this, because it's going nowhere. I don't find any point to what you're doing. I'm not going to micromanage every single.
This is not micromanaging.
Doing it. Yes, it is. You're asking me to micromanage. Okay, the aunt was asleep or not. The child shows up tired. Mom says the child doesn't show up tired, but shows up tired when he goes home. This is not what I'm going to be involved with. All right. I didn't change anything about the parenting time, only the issues between the parents, which need to be dealt with. And you are starting to become the problem. All right. Just from what's going on, just follow the orders.
I've always followed the order.
Appropriate. And the order that I made today is you will do all communication through our family wizard, and all pickup and drop offs will be at the Kentwood Police Department. That's the only thing I'm ordering today, other than also denying a change in parenting time. Thank you both very much.
Thank you.
Is there a child support request?
Nothing was put in about it.
It's in the order, Judge. I literally put it in the response.
You put it in the response?
Yes.
That's not an appropriate motion. You can't ask for something different in a motion, in a response. She doesn't have appropriate notice of it, and it's not a motion before me. If you want to do that, come and pay a motion fee and come in front of me.
Okay, I'll do that.
We're adjourned.
Thank you, Your Honor.
Thank you.
Thank you.
Kent, we have Mr. Kent present with his attorney. Of record is John Engman, but Mr. Block is here representing him. We also have Miss Kent representing herself. This is a motion by the plaintiff father to change parenting time. There was a consent judgment of divorce that was entered 50-50 for the parties. It was entered less than a year ago. It was October 16, 2023. The request really is not for change of parenting time. This is for change of custody. The amount that is being sought. And
I agree. I concur with that.
Mr. Black, you have to meet Vidvarka to even get there.
Yeah.
I'm really sure that that this is Vidvarka. I'll give you a moment. I mean, I know some of the allegations are that she leaves for work early in the morning and a third party picks up the kids 3 hours later to get them to school. Some of these are just are clearly not change of circumstance. When you say that, I mean, there was a CPS report from 6 years ago. She forgot the kid at school. That was way before the judgment of divorce. Some of these things are just rehashing old stuff. And I will say to you that apparently the kids are around a convicted sex offender, and I think it's appropriate, while I'm not inclined to find a proper cause of change of circumstance, I would entertain a no contact, that Mr. Woods have absolutely no contact with the child. I'm kind of tipping my hand, but I've been going at this for 2.5 hours, and I got another 2 or more to go.
Oh my. Yes. So there's three primary concerns that are going on. And these have been going on approximately since March of this year, when the defendant moved to a mobile home on a piece of property near White Cloud. For example, this morning, one or both of the children, I don't know if it was one or both, but one of the children was left at school an hour early without any arrangements of what the child was to do. The school doesn't open till 9. Child was left there at 10 to 8. And there's just been this consistent problems with mom not either home, leaving them alone all day. They're ages 8 and 9. I looked at a picture today that was apparently taken yesterday of dog dew all over the floor in the house.
Has CPS been involved?
I don't believe yet, but there is clearly dog.
Yeah. How does he get this picture from in her house?
I believe one of the children took it and said, "This is what we're dealing with."
All right. Let me, I'll give you more chance here, but ma'am, what the heck's going on? Ma'am?
I cleaned my floor yesterday. And I left my kid at school around 8 today because I thought that I needed to be at court at 8:30. I don't leave my kids home by themselves. I go to work at 9. I leave my house at 7 so I can get my kids to school
But
by 8:30.
So it's an hour and a half to get your kids to school?
No, I leave at 7 so that I can be there on time. And it's only 30 minutes away.
Okay,
So
but that means you're getting the kids to school at 8. What do they do from 8 till 9?
I stay with them until 8:30 and then I go to work. I don't drop them off. I stay.
Why do you go sit there for a half an hour? I mean, I'm glad you're getting the kids to school, but it sounds like this doesn't make a lot of sense to me that you leave an hour and a half before school starts and then get there an hour before and then you sit there. It sounds more like you are dropping them off or leaving with people or.
I leave at around 7 and then I get there about like 8 o'clock and then we sit in the car and then I let one of my kids.
It was only a half hour to school. It doesn't add up. All right, it really doesn't. Do you have beds for the kids in the house?
Yes, I do. CPS bought beds for them because I had CPS at my house.
When did you have CPS at your house?
It was a couple of weeks ago.
Up until then, the kids didn't have beds?
Correct.
No, they did. They had a bed, and CPS asked me if I wanted them to buy 2 beds so that they had their own beds, and I said, yeah, sure.
So they bought 2 beds?
Yeah, I have 2 twins beds for them, and I'm getting bunk beds for them.
I don't understand. If you already had 1 bed, why did CPS buy you 2 beds?
Because they wanted them to have their own beds.
Well, if they bought you 1 bed, they need to have their own bed.
Yeah, they wanted the kids to have their own beds because they didn't wanted them to sleep together.
I understand you're not hearing my point. You got 1 bed for the kids to sleep in. Why did CPS buy you 2 if you only needed 1?
Because there's 2 boys so that they can sleep on one boy can sleep on one bed and the other boy can sleep on the other bed.
What'd you do with the bed they were sleeping on?
I took it out of their room and then put their beds in there.
There's some real inconsistencies here that are hard for me to understand. Are the Mr. Block?
Yeah.
What meets what bar card, or if you could, please.
There's also no propane and no hot water at the house. There's no running water in the kitchen. I think the reason they bought 2 new beds is that one was a mattress that defendant had been given by the sex offender or somebody, and it was absolute filthy mess, disaster of a mattress. What concerning though, as recent as 2 days ago, and this motion has been pending, the children were with this sex offender. Now, I don't know if they were by themselves or accompanied, but they were with the sex offender as recently as 2 days ago. This is what, at least for the interim, what my client is asking for is that the children not be left alone at all. They are coming to his house after school on the bus.
They are not to be left alone at all. They are not of an age that they can be left alone, ma'am. They will not be left alone, number 1. And number 2, they will not be around Robert Woods, a convicted sex offender. All right. Mr. Woods will not be there. We can work on it later if do you understand? Do you understand?
I understand.
All right.
As far as the what the kids do is apparently they're coming to plaintiff's house after school on the bus. And in the morning, the defendant was dropping them off at dad's house, and then they could get on the bus from there. And I think the biggest concern is we're coming into summer, and what are these kids going to do all summer?
Who's going to take care of them, ma'am?
Yes, I'm gonna have my mom watch them.
At your house, or are you taking them to the kids to that house?
At my house.
How far do
I
you
was gonna have my mom stay with me for the week that I have them, and then I was gonna bring her home when they go to their dad's house on Friday.
Is this a Friday type thing, Mr. Black?
Friday to Friday.
It's Friday to Friday. It's week on, week off. That was agreed to last year when things were different and defendant was living with her, I don't know, I think her cousin or somebody. And
I understand. I mean, clearly there's a couple parts of this order that you want that I'm granting. Okay. Number one, kids are not to be left alone. They are not to be around Mr. Robert Woods. Those are two clear orders that I'm making today. My next part is I don't know what the proper cause change of circumstance to have an evidentiary hearing on custody, because some of the stuff is from way before the judgment. Okay. And you know that CPS
Yes.
6 years ago, forgot the kids at school. That was way before the judgment was even entered. And, has the kids around sex offender. That's not great, but I'm assuming that mom does protect the kids. Have to worry about it anymore. There's significant concerns about the environment in which they are in. Only her statements here today are, I don't even understand some of them. That you leave and it takes a half hour to get to school, and I leave at 7, but the kids' school doesn't start till 9. But now it takes an hour to get there, and then I just sit there for half an hour. I can't figure out why that is. And the beds clearly. That other bed must be a piece of garbage if they bought the kids 2 beds. It just doesn't make any sense. But you think that what part of that provides proper cause or change of circumstance?
I'm not sure one item does by itself, but just the mere fact when you add these things up, it's showing that we have a mother who is irresponsible in that, I believe she admitted a couple of minutes ago that she dropped them at school an hour early before the school opened. That is just not proper parenting. That is not a mother being a responsible mother. So I don't know that it's one thing. It's just one thing and another thing and another thing and another thing. And I think if you take them all together, they do add up to a proper change in circumstances. I guess if the court is not inclined to send this to our find that we met the standard, perhaps at least at a minimum, the court would entertain requiring that any time she can't take care of the kids, that they be dropped at dad's house. So if she, for example, can't watch them for a couple of hours, they should be dropped at dad's house. Dad will take care of them.
But I've told her those kids are not to be left alone. Plain and simple. All right. They're not to be left alone.
Yeah.
They're not to be left alone. So you got to figure something else out. Mr. Kent appears to be always available. And if you don't have somebody appropriate watching those kids, I'm going to issue an order that you're going to lose custody. All right. And that doesn't mean, it's somebody that has a CPS record or is a sex offender or some of this stuff. That is not an appropriate person. I'm really close to finding that we should have a custody hearing. Of course, that doesn't mean anything's going to change. I'm sure both of you have an established custodial environment, and you'd need clear and convincing evidence to change that. And that's going to be really hard to do. I am concerned about the condition in your home. You say, yeah, I cleaned it up the other night. You shouldn't have to clean up dog poop off the floor unless it happens right then and there and you clean it up promptly. Nobody should be there taking a picture of it. There shouldn't be more than one mistake by the dog that you clean up as soon as it's there. If not, you're not being an appropriate mother. There's trash outside your house that's clearly a mess, but I can't find that that's enough because it is outside the house. I don't know. What about this propane, ma'am? Did you run out of propane at some point?
I have propane, yes.
Did you run out of propane at one point?
I did ran out and I just got back on propane.
How long were you without it?
I was out it for a week.
What'd you do for hot water and stuff?
Everything's electric. I have water.
What do you use propane for?
Heat.
Heat only?
Yeah.
You have running water in the kitchen?
Yes. I just got my sink fixed.
How long did you not have running water in the kitchen?
It was spraying all over the place, so I had to fix it.
Understand. How long was that going on?
A week when I moved in.
Wait, did you?
And then my brother fixed it.
Did you just move in?
I moved in last month.
Okay, well, you said it was that way when you moved in and you just fixed it. So it was more like a month, not a week.
Yeah.
All right.
The trash outside was from the previous owners.
I'm not really that worried about the trash outside. It was outside. All right. And while it certainly doesn't look very nice and I don't want the kids playing around it and stuff like that, it's trash and it's outside. I'm not very worried about that one. I am concerned about a lot of the other allegations that come up. Mr. Block, the most that I could offer here today would be an evidentiary hearing on the threshold of proper cause or change of circumstance, brings things in to show that. And if you wish, I would have that. I'm not going to find it right here, but there's so much that is so close. And quite frankly, Ms. Kent, you're all over the place in your statements. We have that. I'm concerned about these kids going to school and being left there. You know, your excuse today is you thought you had to be, you know, online for the kids at 8:30. You're online right now. I don't know why you would have to leave them there at 8 o'clock to go somewhere. Did you have to drive somewhere to get online, or are you on your phone?
I'm on my phone.
So then that doesn't make any sense. Mr. Block, I'm going to set up a 1 hour evidentiary hearing for determination if threshold has been met. It's close, and you'll get notice of it. Ms. Kent, you will too. I'm not changing custody, but there is the order, and I want it, no questions in the order, that you shall not leave the children unattended. They must be appropriately supervised by an appropriate adult supervisor if you are not there. And number 2 is Robert Woods is not to have contact or be around the children at any time. Those are the 2, and we will also set up the evidentiary hearing for proper cause change of circumstance. All right, Mr.
Very
Block,
good.
you can draft that order.
I will certainly do so. You're going to do the separate order then for the evidentiary, or?
We'll set up an evidentiary. You can put in there, the court will set up an evidentiary hearing for threshold.
Very good.
In your order, but we will get, I guess we'll contact Mr. Engman's office, or you, or what, to make sure that.
Mr. Engman's office, it's fine.
We'll contact Mr. Engman's office.
Yeah.
Set that up. Good luck, everybody. Thank you. Have a good day.
Thank you. Good weekend.
You too. 0-DC, both parties are present. One, you can have a seat, is in my courtroom, the defendant, and the other is on Zoom. This is a motion by the plaintiff mother, wants to change parenting time to supervised. She claims that there was an incident on 5/11 in which the child Sebastian, who is 7, came home with a bruise on his arm from his father grabbing his arm, and apparently too hard, because he left a bruise on the arm, that the dad was angry and left the bruise there. So she wants supervised parenting time. Father filed an answer, explained how and when this occurred. He says that the kid was acting up in the car and he was grabbing him to put him back in a seatbelt, in effect. And And he admits to grabbing him. He admits to, I think he's talked to CPS and is working with CPS on that matter. That's basically both parties' version and what's going on. Ma'am, do you have anything to add?
Yes, and like I told him, I don't mind him.
No, I'll run my courtroom. I will run my courtroom. No, I don't care what you want.
Sir,
You may leave if you want.
I don't make nothing. I want her under oath.
Yeah, the next thing that he says, I'm gonna call the police up here, okay? She is not under oath. Ma'am, what are you saying?
I was just asking if we can do supervised visits again. Because of what happened, my son was just saying that he's a little concerned also being with him. So I don't mind doing visitations. I can meet him at the park. They can be together. He can come to my house. I have a trampoline. They can be in the backyard.
It doesn't work where he's got to go to your house and be around your family and all that kind of stuff. Yeah, I mean, that just throws gas on the fire.
Okay.
All right. And I know he doesn't deny that something happened, but it's not like CPS was called. CPS hasn't filed anything with me saying, sir, just put your hand down and let me talk. CPS hasn't filed anything. CPS may be working with him on whether it's anger management or whatever. I just don't have enough here to suddenly put in supervised parenting time.
Okay.
That's what I say. All right. You may have a minute to respond, but I just denied her motion, so you're not going to help yourself any.
The only thing I want to say, sir, is that the court order has been breached. I apologize for the opportunity. I just want to be, I'm frustrated because I haven't seen my son in 20 days.
If she violates the court order,
I've done all my process.
file it with the friend of the court, and it will go through the friend of the court and end up with me.
I haven't seen him in 20 days.
I'm telling you, the court order. The court order is the court order. You continue to try and visit. If she does not, you file it with the friend of the court. The friend of the court will look at it. And if they think it's valid, they will put it in front of me for contempt of court for her. You can get makeup, you can get fines, whatever. That's the process. I'm not going to do anything here today. What do you want me to do?
So the only other question I have is, I haven't seen him in the last 20 days. So we just keep to the same order?
Yes, it's the same
she
order.
just keeps not letting me see him.
The
only other option she gave me was to go to her house and
I've just told her I'm not giving supervised. I've just told her, I've just given you what you want. I understand. What do you want me to do? You want me to drive over to her house and get it?
I just like some sort of semblance of order. I have followed this court.
I understand.
As far as I can to the T, sir.
That's fine. Then continue to follow by filing complaints with the friend of the court. That's what they're there for. They investigate him. They do it. I frequently get people in who say, I haven't seen him. Mom denied this kind of stuff. It may be 2 months down the road. And I say, okay, you denied him for the last, he gets another 8 days makeup and he's going to get the following week or something like that to make it up. That's the way it is. Ma'am, if something comes up from CPS that's appropriate, or whatever, you can file.
Okay. Can I just do for Wednesdays? I don't have anyone. He wants to meet at the Wyoming police station for pickups. I don't have someone that can take him on Wednesdays for me. I don't get out of work until 5:15 and then 5:30 on Fridays. So it'll be around 6 p.m. where I can take him.
What's he supposed to have?
4:30 to 4 to 7, I believe.
Not gonna be in school for the next 2.5 months.
Who's he gonna be with?
What's it? Where do you want him to pick him? I mean, I'm not going to deny him his parenting time now.
No, Your Honor. I was having him pick him up from my house with my girlfriend. She's at home, but he refuses to pick him up from her. So that's why I'm asking, can it wait until I get out of work then? Since he doesn't want to pick her up from my house?
Using to pick him up from the house.
She's the one who's
Go
watching
to the
him.
house and pick him up.
That's what I've been doing, but I have been having trouble from the girlfriend. She's been just vulgar. Making fun
You know what? Here's the solution. All right.
Girl, also being an adult. I understand.
Both, everybody, but you got a phone?
Yes. I've recorded the last 2 instances.
All right. He's going to be recording the instances when he picks it up. If that person there is inappropriate, it's going to fall on you. All right. Not the person. You're the one who's responsible. And if that person is irresponsible and I get a motion, it's not going to go well for you. I want parents to be adults. All right. So he will be there at his next parenting time, whenever it is, to pick the child up at his appropriate 4 o'clock time. All right?
So on Sundays, on the weekends, can you implement that because there is an order in place for the Wyoming Police Department. During the week, I can pick them up from my 4 to 7. That's fine. I'll pick them up from the girlfriend if I have to. But I would like for on Saturdays and alternating Sundays, I would like it to be from the Wyoming because I just don't feel safe around that
Your
environment.
Honor, I have cameras at my house. They can be whenever he'd like. I work on the weekends sometimes when I volunteer at work.
When you volunteer?
Correct. So a couple of weeks ago, we worked at 7 in the morning on Saturdays. So we volunteer in our community. So that's the only reason why I would need him. I can do my parents' house on the weekends.
Well, what about your parents just transporting to the Wyoming Police Department? What's such a big deal about that?
Well, I don't know if they'll have plans to go out or anything like that. That's what I'm saying. The days
The child takes priority, okay? The child takes priority. And I'm making the priority with you and with him, all right? I'm getting a lot of excuses in why we can't do this. Parenting time on the weekend, the exchanges will take place at the Wyoming Police Department.
Okay.
All right. During the week, he will pick up from your house, from whoever is there, whether it's your parent or this girlfriend. Be aware that he's going to be recording his pickup. All right. And once again, it is up to you. You can't come in and say, well, that was my girlfriend. I didn't know what she was doing. You're responsible. All right.
Can he be respectful to my girlfriend? Because he's
Absolutely.
the one.
You can record it too. If he's not respectful, trust me, he knows I'm going to whack it.
I would hope so.
All right. I'm not going to play any games. Good luck, everybody. Motion for change of parenting time is denied. Parenting time on the weekends will take place at the exchanges at the Wyoming Police Department. Thank you both very much. We're adjourned. Yes. It is the matter of, she's not connected yet. It's the matter of Valdez Diaz versus Cruz. No, you got to connect.
Tiene que conectar usted.
She's not connected. You're all right, sir. This is the plaintiff's motion to amend the order of genetic testing. The court issued an order for genetic testing because there is a child, Scarlett, I believe is her name, and 3 years old.
Scarlett es el nombre, creo que tiene 3 años.
And she says this is not Mr. Cruz's child.
Si no es una hija. Yes, it's not his child.
Well, the court issued an order for DNA testing to determine if that is the case. It was back on the 30th of January.
Era ya el 30 de enero que se hizo.
That is still an appropriate order, and even though that Mr. Cruz has been defaulted in this case, is still considered a DM.
Un caso de M.
And will be until we find out who the true father is of Scarlett. Mr. Cruz, you are ordered to take a DNA test with Scarlett to find that whether you are or are not the father. Are you going to take that test, sir? Hold on. Stop.
Momento. Your Honor, I don't have a reason to take the DNA test. And you can see she's not taking this seriously by her expressions there. But sir, I have not been with her since 2018.
Well, let me just tell you this, Mr. Cruz, that unless you're proven not to be the father, you are going to be the father and you're going to be paying child support.
Pero ¿por qué tendría que pagarlo yo si ella vive con su pareja y la niña está registrada con el nombre de la persona?
But why should I still have to pay if she is living with her partner and the child has their name?
Because the law says you're the father because you're married at the time of conception or birth. End of story. Since you have been defaulted in this case, she can enter a judgment here pretty soon, and you will have the pleasure of paying child support. That's the law. You apparently don't know.
So I understand the law. She's the one that doesn't for having had a child within the sanctity of the matrimony.
Doesn't matter. You're the father unless you prove you're not. You're either going to take the test or you're not. If you're not, you're going to be the father and the judgment is going to say that you are, and you're going to pay child support. And they're going to garnish it from your wages.
Okay, ¿puedo pedir la palabra? Can I say something?
Briefly?
Brevemente.
Okay. Él reconoce que es mi actual pareja.
Stop.
So first of all, I want to say something to the effect that he's saying that I don't understand the laws. I do understand the law. The second thing I want to say is the biological father of the child is. ¿Quién es el papá biológico?
Mi actual pareja.
my current partner.
Prove it to me.
Pruébelo.
DNA.
Ok, yo lo puedo Jesús, por eso yo no
Hold on.
podía hacer una prueba de ADN.
Stop.
And so that's what I wanted you to allow me to do, to have a DNA test with my current partner to prove that he is the actual biological father of the daughter.
Don't care where I get it from as long as I get proof. If Mr. Cruz proves Mr. Cruz proves he's not the father for the DNA test, or you can show who is the father, I'm fine. Your motion to amend the order of genetic testing is denied. You know what you need to do. He does not prove that to me, Mr. Cruz. You're welcome to start paying child support when the order comes through. Thank you all very much.
Usted tendrá el placer de empezar pagando el soporte.
We are.
Yo lo voy a entregar.
I've got to move on.
Por eso yo había llenado el emotion que él pedía.
Your Honor, should I interpret that?
I don't.
So yo a mediados de la semana entrego la prueba de quién es el padre de mi
my order.
Señora, ya está el orden así como está.
Okay, gracias.
Ms. Rocco, thank you once again very much. We're adjourned. Okay, thank you.
Thank you.
Give me one more. I don't lose my temper. Can you both hear me?
I can hear you.
All right. I almost feel like I should call you Kayla and Todd because I've seen you so much lately. And you've been upstairs to Judge Hillary. I know that this is a motion now by the father, a ROPA motion to find that the DNA shows that Mr. Bradford is not the father of Sebastian. Isn't that correct?
Correct.
And ma'am, has he had any relationship with Sebastian? I mean, does Sebastian look at him and say, hey, Dad, and this kind of stuff?
No, he does not.
All right. All right. Mr. Bradford, you agree with that? And you're asking to be declared that the child was born out of wedlock at this point and that you are not the father, correct?
Yes, I fully agree with that.
Pardon me?
Yes, I fully agree with that.
All right. I will issue the order that Sebastian was born out of wedlock and that Mr. Bradford is not the legal father of Sebastian. All right. That'll give you whatever you got to go on with the divorce and stuff like that. Okay.
Thank you very much.
I'm sorry about the wait. I know you've been up in Judge Hillary and down here and stuff like that. And good luck. Both of you have a good weekend. Okay.
Okay.
Thank you.
I am sorry, Your Honor, but my daughter is not his.
I don't have anything on the daughter. Wasn't this a test for Sebastian?
Yes.
Mildred.
The DNA test was for Sebastian, right?
Yes, it is.
All right. Sebastian is a child born out of wedlock. I don't know about anybody else. Nobody else, the best of my knowledge, nobody filed anything to say she was born out of wedlock. Mr. Bradford, I don't remember you filing that.
No, I did not. I fully believe she is my daughter and don't care either way.
She is at this point. He is the legal father. Unless you can somehow file a ROPA motion that I should look at and grant. But even if he is not the biological father, the court will have a hearing because he believes that even though he may not be biological, that he should not be taken off. And there's a chance that biology isn't the most important thing in being a parent. But I'm telling you, there is nothing in front of me to indicate that your daughter is not there. I'm making the decision that Sebastian is born out of wedlock, and that's all. Good luck.
Thank you very much for your time.
Thank you. Grael versus Grael. This is a motion made by the plaintiff mother. First part of the motion basically is to modify, if you will, the judgment that says each party gets 3 weeks of summer parenting time. And she's correct, Mr. Grael. I don't know what, because you guys last hearing, you got week on, week off. There's no reason to give each of you a separate three weeks in the summer. Do you agree also, Mr. Grael?
Yeah, I don't object to that. The only thing I would ask is that it would prevent to exercise our vacation time for the weekend, because I don't know that the JOD requires modification with it being week to week.
Well, nothing, no, all I'm gonna do is vacate the fact that, you get 3 weeks each of summer parenting time because you each get 5 weeks of parenting time, all right?
Yes, sir. So
Just figure out your vacations on the time that you have the child.
okay, perfect. And then do we need to the also said 30-day notice? Do we need to do that or anything?
You don't need any of that anymore because you got week on, week off. So from here on, out, you're just doing that. Ma'am, you're not driving, are you?
No.
All right. So that's pretty self-evident and that's fine. The other thing is that, the judgment calls for, 22 tax return will be filed jointly. And as of now, it has not been. What I have here is that, Mr. Grael apparently says he's not gonna do it until his 2020 tax return is signed by you or modified. That's not in the judgment, so I'm not gonna deal with that. Mr. Grael?
Yes, Your Honor.
Joint tax return, that's what's in the judgment, and that's what I'm gonna enforce.
Yes, it already has been signed. The reason why we didn't sign it or we had a delay was because they recommended amending the 2020 taxes. So knowing the implications of that, partnered with the CPA and then the financial advisor to discover what steps we needed to take. So the 2022 taxes have been filed and sent in and signed, and I agreed to the pay half of the refund to her.
Yeah, you guys have that. That's all in there. The only thing I'm gonna do is enforce the judgment. Ma'am, I think you got the two things that you wanted.
Yes, Your Honor. I did have a question though, because the taxes were just signed 3 days ago. So I was requesting, due to the lack of cooperation and me being unable to file bankruptcy due to this, there was a judgment of garnishment set out for me. So I'm just requesting that Ryan pay for the tax preparation and the late fee of $260 because I have been trying to communicate and work with him.
Here's one of the problems is that you got to understand, and you don't understand it. When you file something, you can't come in on a Friday morning and change what you're asking for. Okay.
Right.
Because it's got to be noticed to each party. So realistically, this wasn't even part of the motion. It was to get him to sign the 2022 tax return. It's done, it's over, and that happens. I'd have to have a lot more information before any of that would even come before me, such as showing me this, showing me why, all this kind of stuff. And I'm not going to have Mr. Grael respond to it because he's got to have notice of it. So anything else, I'm granting your motion about vacating the 3 weeks in the summer, and the 2022 tax return is really moot at this point. Okay. All right. Good luck, everybody. Thank you. We are adjourned.
Yeah. Thank you.
DM. Both parties are present with their respective attorneys. Ms. Dawson represents the plaintiff. Mr. Van Elderen represents the defendant. There are two children in this case, and this is the father's motion for parenting time and custody. Looks like there was a custody and parenting time order in February of 2024. It was from the friend of the court, but it was signed. Okay. And it was entered in 2/22/24. Like I say, this is a pleading for change of custody. And the only thing that I really have for any change of custody, proper cause or whatever, is all I know is dad's now out of jail. That doesn't provide Vidvarka standards. It's your motion. Mr. Van Elderen, if you wish to say something, I think the only thing that I really need to do is set some specific parenting time because there is none in the February 22 order, but go ahead.
That's correct. And then, as I said, I'm just getting onto this case this week. I was retained on Wednesday, so I'm trying to get myself up to speed. There is, my client indicates that he was not made aware of some of the proceedings that led up to that custody assessment and all that. So I'm trying to get to the bottom of that. Obviously, I can't. I tried to request the documents, but the file's with you, so I can't get copies of that stuff yet.
I've got it hidden in my office, so you're not going to get it. Okay.
Exactly. So as far as that aspect of it goes, I do want to take a look at what's going on there, but I do think that certainly we need to establish a set parenting time schedule because parenting time was as the parties agreed, and they're not agreeing on
right. And Ms. Dawson, court says I have to set specific parenting time. If they don't, I can't leave it if one party or the other says I need a specific time, so I do have to set that. I know that the case is at the front of the court right now for child support, I believe, for child support review. I saw that referral there. And there is that order from February of 22, and I, of course, have nothing to potentially change any custody in that order because there's nothing pled even regarding Vidvarka. But I assume you agree that I do have to start setting some specific parenting time for the father.
I do. However, I would like the court to know that it's my understanding. I also am coming into this a little later. I was not present for the February hearing of any kind. I was only retained about 2 weeks ago.
February order was an investigation by the friend of the court. Nobody objected to the order, so it was entered.
Okay. And so from what my client tells me, that it's not as though she wants to necessarily keep the children from their father, the defendant, but he's not stable yet. He doesn't have his own place, and my client doesn't feel comfortable with the children spending the night at the residence in which he is staying. So I think I understand you have to set some parenting time, but at this point I would request no overnights until the defendant can establish that he has an environment.
Let me ask you a couple questions because I don't know anything about him. I don't know where he lives. I do know that he's out of jail now, so he is living in the free world. Mr. Van Elderen, where does it?
So my understanding is Mr. Insky is currently residing with Ms. Kimball's sister, which was something that prior to his when he was actually went in for his sentence, that was something that was discussed between the parties, something that she had recommended to him, that would be where they would. Where he was,
he's living at mom's sister.
Yeah.
Right.
And it's my understanding that it's kind of a transient household and that the sister has displayed some concerning mental health instabilities and made comments that she just simply does not want her children around. And it's also my understanding that this mental instability has kind of become more apparent more recently.
You mean since she recommended that Mr. Insky stay there and now she doesn't like the fact that he's staying at her?
Correct.
That's not a real convincing argument, but go ahead. I mean, when was the last time Mr. Insky has been able to see his kids? Maybe one of you can answer that.
I'll defer to his counsel because I don't know.
I think my understanding is he's had a couple of very brief visits. I think 3 hours or something, like 2 or 3 hours. I'm not exactly sure what the entirety of the schedule has been, but he's made efforts to exercise more longer stretches and more parenting time he's been given.
Why don't we start out, because he's got to see his kids, and the longer he's away from them, the more estranged they are, if you will. So what was he seeing the kids before he went to jail? How long were you in jail?
They were doing 50-50 pursuant to the judgment, and his understanding was that he was going to do some, maybe not full 50-50 when he got out, but there wasn't the custody filing after he started his jail sentence came as a shock, because that was not what Ms. Kimball had represented to him.
But quite frankly, it shouldn't be a shock when somebody goes to jail that they lose some custody. That's kind of a one follows the other. When you go to jail, you can't have custody of your kids, and you can't even really see them when you go to jail. I don't even usually allow parents to take the kids to jail to see the other person. That's one of the penalties you pay when you went there. So all of that having been said, Mr. Insky, I mean, these kids are what, 7 and 4 or something like that. They're not tiny. They're able to, and he played a substantial part in their life. His place of where he's living is not particularly stable, apparently, even though it's her who suggested he go there, and now she doesn't like it. I'm going to start out just right now with some parenting time, and we can, if you want, I can send it to the friend of the court, or we can have a quick hearing on it and determine what's best. But for right now, I'm gonna give Mr. Insky every Saturday from 10 o'clock till 8 o'clock at night. I mean, it's not a school time or anything like that. Unless you'd rather make it 9 till 7, you can have them every Saturday.
I would defer to my client if she has a preference, but given the age of the one child is rather young, it would be my personal opinion that a return time of
It's a
9
weekend.
o'clock is kind of late
It's at
for
8
a little
o'clock.
one. Oh,
All
8
right,
o'clock.
8 o'clock. 10 till 8 every Saturday. We'll give him, I don't know, Mr. Insky, are you working? I can't hear you because you're on mute.
Yes, I work.
What are your work hours?
I work every day or Monday through Friday, 5 a.m. to 3 o'clock in the afternoon.
All right, so no reason you can't have every Wednesday afternoon also from, say, give you a chance to get home. Are you far from the kids?
No, I live right in the school district. I'm right down the road.
All right, well, let's just do 4 o'clock till 8 o'clock on every Wednesday. All right. That's just, I want everybody to understand, that's just a starting point. All right. Because I want him to start seeing the kids frequently. He'll see them twice a week and we'll move on from there. All right. I'm trying to determine whether or not I should send it to the friend of the court or just have it in here to make a hearing. Why don't I send it to the friend of the court for parenting time evaluation and see what they think. I would think that once you have I don't know where your place is like to live at, sir, but once you've got your own place and stuff, I'm assuming that your time in jail was not for child abuse or anything like that. What was it for?
DUI, sir.
All right. You don't have to be drinking while you have the kids either.
I've been sober for over a year, sir.
All right. Well, I congratulations. I'm really happy for you, but I want in the order that you will not consume any alcohol 12 hours prior to or during any parenting time. Should be no problem for you. All right.
Your Honor, may I also make one comment?
Yeah.
It's my understanding he does not have a license, so it should be inherent that he is not driving with the children at all.
Yeah, I'd imagine your license was taken from you for the OUIL, wasn't it?
Yes, sir.
How are you going to transport the kids?
I have people to get me back and forth to work. I have people to get me to places I need to be.
All right. All right. Can we do that the person getting the children is responsible for the transportation? So in other words, Saturday morning, sir, you have to pick up the kids from her house, okay? And
She drops them off at the babysitter, so I would have to grab them from the babysitter.
All right.
Which is another thing. That's the reason why I brought this to here, and my attorney is aware of what the babysitter is at and doing. So
you'll get a chance to talk to the friend of the court and do all kinds of things with them.
Yeah.
And if you don't like their recommendation, your attorney and you will talk about it. You'll file an objection and we'll proceed from there. I don't like doing this necessarily, but I'm going to waive the costs for $150 from each of you. You just got out of jail, and I can't imagine you got a lot of money saved up after spending that kind of time in jail.
Well, I've been giving her money every 2 weeks too, so
that's fine. And I'd rather that happen right now. All right. I'm waiving your fees right now. 150 would come from each of you. Otherwise, I'm waiving your fees. We'll refer it to the friend of the court for a parenting time evaluation. In the meantime, you will get Saturday 10 till 8, Friday, Wednesday, what did I say, 4 till 8. Make sure you have appropriate transportation. The person getting the children is responsible for the transportation. So at night, mom has to come pick them up from you. Both of you will act appropriately. If I find something different, it really ticks me off, and I will do something to the person who is not appropriate. You understand that? Act like that. All right, everybody.
Yes,
Mr. Van Elderen, you're the one. Your client's the one who filed the motion. I'll have you.
I can prepare an order, Your Honor.
All right. Make sure you send it through Ms. Dawson so that you guys can. So if you have any problems, you guys can argue about it without me. All right. Anything else? Good luck, everybody.
Thank you.
Thank you.
Thank you. When does it start? Can he start tomorrow?
Ms. Kimball, Are the kids available tomorrow?
Yes, they are.
All right. Thank you very much. Start tomorrow, sir. Take 'em
All right,
up.
thank you.
Thank you. Good luck.
I have another case as well.
Well, are you telling me that you want me to hear it or?
I mean, if you have time, I would
No, I don't.
appreciate it. I mean, I didn't think you were busy today at all or
No,
anything.
no, no. I just think I've been going since 8:30 and I think I still have 10 or 12 left. So
That's what I heard.
which one are you on?
Stokely?
Stokely?
Yes, I'm standing in for Therese Pauletta.
You know, I saw the file, but. Oh, yeah, it's number 20.
And just a note, you were my professor, I believe.
Oh my God. That was probably, no, I'm not gonna say anything about your problems in working in this area to be blamed to me now, okay?
No, actually, I remember you told me that if I answered in a certain way on your exam, I was going to fail. And I was like, got it.
Did you answer it a certain way? Did I fail you?
I answered the way that you told me to, not the way that I felt was right.
Oh, geez, Pete. Well, it doesn't matter because like when I'm sitting here, I'm right. Right? It's like when they call you out at first base and you know you were there and the umpire says you're out, you're out.
You're out.
Oh, all right. Do you work with Miss Pauletta?
I do.
Okay, so you're out there with Kevin Peterson and.
Yep, I joined them last year.
All right. Good for you. We have Mr. Stokely on here and you are here for, let me see. You're here for plaintiff or defendant?
I represent Mr. Stokely, so I believe that he is the defendant in this case.
Yes.
And then Miss McKee, is that how Mackay? Ms. Mackay is the one that filed the motion.
Yes, it is. Versus Stokely. Ms. Mackay, who filed this motion, is present. Mr. Stokely's attorney, Ms. Dawson, is present. Mr. Stokely is not connected, and unless you guys want to all go back in the waiting room and wait for a lot longer, I'm going to kind of proceed. Ms. Dawson, can you proceed?
I feel comfortable proceeding, yes.
All right, we'll continue to try and get him to connect. This is a custody motion filed by the mother, stating that Hunter was beaten and duct taped, basically, by dad's girlfriend. CPS, I was provided something from CPS that says, basically, quote, was found a preponderance to support allegations of placing the kids at unreasonable risk. That's nothing more. CPS, I don't think has filed a case or anything. I don't know if there's services in place. And she is asking for a change of custody. I'm not certain that VARCA is met, but ma'am, tell me what more you know.
I just yesterday at 4:30 got the full report from CPS. They opened the case as ongoing, and did fully open it. It's let me read what it was, the second highest ranking. They are doing services.
They do have services.
Yes.
That are being provided to apparently Mr. Stokely and his, I don't know if it's his girlfriend or his wife or what.
Girlfriend, yes. I guess she didn't only duct tape Hunter's mouth and put him on the wall and spank him and denied him water. They got into an argument about it after CPS came and they were on I-96 with the kids. And Mr. Stokely and Katrina were hitting each other and Katrina grabbed the steering wheel and swerved the car. And they found a preponderance of evidence supporting that. And that's where the unreasonable risk substantiations came from as well. I do have that report and I tried submitting it, but I just got it too late yesterday.
Well, your CPS reports aren't really to be just filed with the court. In fact, I think there's some amount that says it can be a misdemeanor if you're just putting it in the file. If you file that report, you need to file it kind of under seal for my eyes only and for the other attorney's eyes. Okay, I can't have you just file it in the file. Okay.
Okay, I didn't know that. I'm sorry.
Ms. Dawson just said I was a professor that taught her some of this stuff, and I'm now your professor teaching you some of this stuff. All right. I just don't want to. I mean, I'm not going to violate you for it, but I just want you to understand. You can file a copy of it, put it in a sealed envelope, make sure the opposing counsel has to get everything that the court gets, okay?
Okay.
And make sure that it's in place for that. And as you know, they probably will help you enough downstairs when you file it to say it's you know, under seal for the judges or referee's eyes only. All right.
All right.
All right. But they have not, I mean, they clearly haven't filed a petition, I guess, against.
No, they said that they're not going to file a petition unless more arises. But they opened the case and are leaving it open.
All right, Miss Dawson, it's not looking real good for your client, but tell me what you can.
Well, I have not seen this finalized report. As Ms. McKay indicated, it was sent to her yesterday at 4:30. So I have no idea what is contained therein or what the findings were. My client was under the impression that it is still open, but it was unsubstantiated. That appears to be in dispute according to Ms. McKay.
Well, I'm reading you here what they said, okay? Preponderance to support allegations placing the children at unreasonable risk. I do have that from Tonka Kruger. From that is in my documents here. Okay. So I mean, if they found a preponderance, that means they clearly have opened the case and substantiated it. All right.
And so my client does tell me that he is and has been working with the Right Door and following their recommendations. I think it's important for
the Right Door.
The Right Door is a community health resource center in Ionia County that provides a lot of mental health counseling and services to the local Ionia community. And so it's my understanding that he is working with them and the kids are seeing a counselor there and all of those things. And I think it's important to note that this CPS report really goes against the girlfriend and not Mr. Stokely himself.
No, but as long as the girlfriend's there, she's part of it. He can kick her out if he wants. I don't know, but I can tell you one thing that I'm gonna order right now is she is not to ever be left alone with these children. Under any circumstances. All right, until we get more of the bottom of it. All right.
And I would like to highlight, if this, as you indicated, is a substantiation against the girlfriend, there's still not a substantiation against him necessarily. And this is, and if there is, it's the first one where it's my understanding, and I'm a little late to this party here. I understand this case has been ongoing for quite some time, but as Ms. Pauletta filled me in, there have been multiple CPS calls against my client, and some of them are suspected to have been made by Ms. McKay. And it's also my understanding that she has several CPS substantiations against her. So I just want you to, I kind of want to say that to jog your memory, and also go back to the first thing you said is I don't believe that she's met the threshold to change custody necessarily.
Well, it's getting in the ballpark when somebody is substantiated with the CPS. It sure starts looking to me like there's a change of circumstance when the CPS comes in and says, we're substantiating. And I understand it's not against Mr. Stokely, but when you practice child abuse cases, CPS comes in and makes the kids a ward of the court, okay? And every judge will tell the father and mother, if you're going to be with somebody and they're not appropriate, you are at the same risk as they are, all right? You either are with them 100% and, if they fail, you fail even though you do great. And that's what this is right now. As I'm telling you right now, Mr. Stokely's significant other, and I don't know what her name is right now, but we're going to put it in that order, is that she has been substantiated. She is not to be around these kids at any point unsupervised from this point on until further order of the court. That means if Mr. Stokely goes to work and the kids are there, he's going to have to find a sitter for him or something. She is not going to provide any services for these kids. He better be there and he better be watching out for the kids, all right? Because if any of this stuff goes on, he's responsible, and he's even responsible for this one because it's his girlfriend, not mom's girlfriend or boyfriend, all right? Now, should I find proper cause or change of circumstance for a custody change. I suppose there is a change of circumstance in the kids, but they're also, at least at this point, at least according to Ms. Dawson, there is services in place and whatnot to protect the kids and to work with the kids on this. Ma'am, Ms. McKay, have you been informed of any of that?
Just in the report that I read yesterday from CPS, it did say that they were participating in some services.
All right. Then, and doesn't the custody change to more to you in the summer?
It does, but supposedly Belding schools shorten their summer and they get out in August, so I'm only going to get actually 6 weeks total with the kids over the summer.
I understand. I'm just saying for right now, I'm not as concerned because the kids are going to be a lot more with you than they are with him. All right.
Yeah. Yes.
And so I'm not going to have a custody hearing right now. I'm not going to find necessary proper cause or change of circumstance, but I am going to leave it open for you if you think it's appropriate, or certainly if you find out that the kids have been left with this girlfriend without Mr. Stokely there, you can renew this motion at a heartbeat. Okay. Ms. Dawson, you know what I'm talking about this, and Mr. Stokely, you better too. I'm not going to play around with this. That is way over and above discipline. Okay. You don't duct tape a kid's mouth shut, and I don't care what it is. And they found a preponderance of evidence and they have substantiated against you. You are this close to having a custody hearing to potentially, don't know what, to potentially changing custody to mother. Mother, you've got, like I say, it's time to calm down this summer because you're going to see the kids a lot more during the summer. And if you wish to renew your motion by renoticing it for some time later because you think I really need to look at this and you want to provide me more information from CPS later on, you can do that. Let's see how it goes. All I'm really interested in, all I really care about, quite honestly, is your kids. I don't really care about you, Mr. Stokely, or you, Miss McKay. These kids have got to be treated better no matter where they are. And I'm not going to put up with this kind of stuff at your house, Mr. Stokely. Not even close to it. All right. Do you hear me?
Yes, sir.
Make sure you talk to Miss Dawson about this. All right. Because there won't be a second bite of the apple. I can guarantee you. If CPS substantiates against you again in the near future, the kids are going to go to mom. We're going to have an evidentiary hearing about when they should come back to you, if at all. You understand that?
Yes, sir.
If it's any consolation, Your Honor, I did have a conversation with Mr. Stokely yesterday and we discussed disciplinary tactics and the like. So I do feel he understands the message.
I mean, I hope he understands. You hired an attorney and there's a reason for it, sir. You don't hire an attorney and then don't listen to him. All right. Miss Paletta has been with you there all along, but Miss Dawson has learned a great deal from Miss Paletta and the firm that she practices with, and she knows what she's talking about. All right. So at this point, I'm not going to change custody. I'm not going to enter an order hearing that there's proper cause of change of circumstances. If anything, I will defer that to a later time if more CPS stuff comes in and I think I need it. Ma'am, if you need to file CPS because you want to renew this motion, make sure you try and do it at least under seal so that the judge or I are the only ones to hear it, and make sure counsel for Mr. Stokely gets it. Okay?
Okay.
All right. Good luck to everybody. Miss Dawson, you're the only attorney, so you're going to draft this. It just, the court at this time does not find proper cause of change of circumstance for an evidentiary hearing on custody. However, you got to put in that stuff about the girlfriend, and I don't know her name, but you can certainly get it from Mr. Stokely, is not to ever be left alone with these children.
Okay. I will put that in there.
Good luck, everybody.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you.
Hey, Annie Rose, I need you to be very quiet because it's my meeting time now, okay? It's just starting, so I need you to be very quiet, okay? Just for a few minutes. I'll let you know when it's finished, okay? I can't hear anything. Okay, now I can hear somebody. Okay. I couldn't hear anything on my laptop or my phone a minute ago.
Ms. Ramirez, can you hear me?
Yep, I can hear you.
Mr. Gonzalez, can you hear me?
Yes.
All right, you're real quiet, but All right. We are here on Ramirez versus Ramirez. This is a motion that has been filed. Both parties are present on their phone on Zoom here. And this is a motion that has been filed by the plaintiff mother regarding child support. She wants the child support for the child who turns 18 in May to continue till next May when there's graduation. Ma'am, does this child still live with you
Yes,
full time?
yes,
Has been going to school full time all along?
yes,
And is just expected to graduate next May, correct?
yep, that's right.
From what school?
Comstock Park High School.
Okay. Sir, I'm inclined to grant this because that's what the law calls for, is that the child can be past 18 as long as they are in school full time and living with the recipient of the child support. What do you want to say?
I was just gonna say, when the last time we spoke, you had mentioned that that was not.
Speak
gonna
up.
be the case, that-
What?
The last time that we spoke, you mentioned that was not gonna be the case. As soon as he was 18, he was gonna be off. So I don't understand what.
When did I say that?
On the last time that I set up an appointment for this, when I was trying to do a motion.
When you were in a motion? Well, did I even know that your child wouldn't graduate then?
I mean,
I probably assumed that it would be 18 or graduation, which is this, but I'm finding out that your child is attending school full time, which you must know. You must know that the child's attending school, right?
I've talked to my son, and he says that he's gonna only go back to school. I feel it's all because of what she's doing. He's told me so many things about how he doesn't even get any of the money from her or any kind of help, really.
That's not,
living with her,
don't
so
go there. That has nothing to do with
I
this.
mean,
I'm
I
not
don't know
gonna
what
get
to do.
into
I
it.
mean, I'm just being like going on what they're telling me. So
The child support will continue until graduation, which will mean through end of May of 2025, provided that he is in school full time with the expectation of graduation and living with the mother. If in fact he drops out of school, if in fact he isn't living with the mother or something like that, you can come in and I will probably cancel it. But other than that, we'll continue the child support until through May, through the end of May of 2025 with the understandings that I just placed on the record. All right. Good luck, everybody. Thank you, Mr. Arnson. We were a long time ago and we were supposed to bring in Mr. Cox, and I said the only thing they have in common is their hair.
That's right.
It's easy. If they're both looking down, I can understand where you wouldn't know. All right. You are here for Mr. Oaks?
That is correct, Your Honor.
Okay. This is the matter of Oaks v. Oaks. Parties are present. Mr. Oaks is present with his attorney, Mr. Jeff Arnson. This was the mother's motion regarding custody. I think the judgment of divorce in this case was from July of 2022, and the parties have been in front of me way too often, and it's not even 2 years old. The mother is asking for a change of custody. It appears that one of the primary requests is because the father has moved away to Hesperia, which is about an hour away from where they lived. The judgment calls for week on, week off with exchanges at 8 p.m. on Sundays. Now, mom says that she's had the kids since February of 2024. Ma'am, is that, you've had them exclusively since then?
He's taken them every other weekend since then.
All right.
There was a break from February to March based on the February 8th incident that was turned into the courts a while ago. But since he's moved to Hesperia, I've had them consecutively on his weeks and mine.
Okay, but he visits on weekends, you're saying now?
Correct.
All right.
Every other weekend.
Yeah, and that the father recently involved in an accident and all kinds of stuff. And do all three kids, I mean, you got them 16, 14, and 8, do all of them attend Cedar Springs School?
No, our daughter Elena is at Cedar Springs Schools. I pulled our son Logan from Cedar. He's now enrolled into Graduation Alliance, which is a credit recovery program. And
Where is
then
that out of?
he does that remotely. It's through Northview Public Schools, but it's a remote program.
Well, he can basically do that from anywhere.
Correct.
All right.
And then our 8-year-old is homeschooled still.
All right. Let's see. Mr. Arnson, it sounds like, it sounds like your client is kind of allowed for every other weekend and stuff like that.
Well, I would disagree with that assertion, Your Honor. This stems back from the previous motion. It was filed by Ms. Behrens and was ultimately adjourned without date. She withheld the children after this incident, without an ex parte.
Did your client file with a friend of the court?
I don't. We had filed a responsive pleading asking for make-up parenting time based on that. It was Ms. Behrens then adjourned the hearing, and the parties were going to try to work it out, make-up parenting time, but it became clear pretty quickly that I don't think that these parties can agree on anything. So I think he's been trying to tread lightly. He didn't want to bring her back to court, didn't want to bring in front of the friend of the court, simply to try to resolve some of these issues between the parties. As I noted in our response, one of the reasons Mr. Oakes moved far away is, one, he was living with, he had a rental situation with a landlord. The landlord, Ms. Behrens, knew, based on Mr. Oakes's position, she caused a lot of problems and caused him to be evicted. Ultimately, he could have stayed there a little bit longer.
I don't even really care about that. He moved to where he moved to, okay, for whatever reason.
Correct, okay. Your Honor, the issue here is that the issue of the school, Ms. Behrens unilaterally enrolled the oldest kid into the school without discussion or agreement from Mr. Oakes. So clearly a violation of joint legal custody. And she's just been dictating where the kids go and where they don't.
Let me ask you this, the oldest son, does he have an objection to the credit recovery thing that he can do from home and this kind of stuff? Because then if he does, then I got to have a Lombardo hearing on it. And it sounds to me like that actually plays into his hand, because he doesn't have to transport that kid anywhere. If he were to have week on, week off, he can do everything from his house just as easy as he can from her house.
Yeah, I haven't talked specifically whether there's issues in that regard. I know, he doesn't believe that the youngest child should be homeschooled anymore. So that might be.
But they have been homeschooled, as I recall, for a long time.
Correct.
And if he wants to fight that, that's a Lombardo hearing.
Exactly, and it's an issue that's on the table, and I don't think we've completely discussed whether the oldest child. My client is able to get the kids to and from school. The issue being, potentially with the youngest kid who's homeschooled. It is about an hour drive, but with busing, the kids are spending about an hour at the bus stop and an hour on the bus regardless. So
I understand that. My kid used to ride the bus for an hour from Rockford over to the west side and back, and it was until Dad broke down and just started driving him, and then we got him a car.
Yeah.
And I understand this is no fun for kids to be an hour on the bus, and he probably doesn't spend any more time in a car than he does in the bus. But that really isn't the issue very much. The issue is if he's not exercising week on, week off and things like that right now. And I don't know if he even has a car or whatever. He apparently got in an accident. Is that all taken care of? And
but my understanding it is, yes. And I think moving forward, I think one of the issues is the parties unable to agree on transportation where they're going to meet. Based on the move alone, our reading of the law is that the threshold has not been met to change custody or parenting time.
Well, I don't know that just the move alone does it, all right, but there are going to be some practical issues that are going to be taken care of, and I don't think necessarily the move alone is a change of circumstance that warrants a custody hearing, right? But there's a lot of stuff going on in this case that has to be taken care of. First and foremost, if your client was denied parenting time that he was allowed, he needs to file it with the friend of the court. That's the appropriate way to follow through on it. If the friend of the court accepts it or whatever, and then I'll eventually hear whatever, if they can't reach an agreement. That's just, I'm certainly not going to make any rulings that he's entitled to 21 days of makeup or anything right now. I don't know what the situation is. You can file that with the friend of the court as long as it's done within, I think, 6 months.
Very good.
mediation would be great, but I don't know if these two parties can mediate.
I have asked Mr. Oaks if he was willing to go to mediation with me on May 2nd, and he did not respond.
Mr. Arnson, there's so many moving parts in this. The youngest kid is homeschooled. The middle kid goes to Cedar Springs. The oldest kid is online. All right. Kids are going all over the place. I understand that Miss Behrens has been homeschooling these kids ever since I've had this case, and I've had this case in front of me many times, and they aren't even divorced for 2 years. All right. It's kind of says something about the parents, but regardless.
Yeah, I think that, I do think mediation might be appropriate in this scenario, and I don't want to besmirch Miss Barron's name or what she's been trying to accomplish, but when the times the parties were trying to work stuff out, my office was inundated with several emails. I know it's important to her, but it's hard to get to the crux of the issue when there's numerous emails and numerous paragraphs and
I find the crux of the issue is what are we going to do come next year? All right, because the kids are not in school now, and quite frankly, if they're not in school, it should be week on, week off. Kids just aren't in school. Right?
Our son has started a job at Walmart, which he applied for the job before we were made known that Mr. Oaks had moved to Hesperia. Mr. Oaks will not transport him to work. I have had to do all the transportation. He has not taken our daughter to school since February 8th.
I'm telling you that again, we're going all off here. And I'm telling you that right now your kids are not in school. All right.
Correct.
So we don't have to worry about that. It can be week on, week off right now, but we're going to have to worry about this come, September 1st or something. We've got to reach some kind of resolution. Mr. Oaks, I can tell you that if your son's working, he's going to have to get to work. End of story. All right. I don't know how much he's working or whatever. Mr. Arnson, that's something that, I'm not going to make the kid lose his job. And if dad can't get him there, then he's got to stay with mom and on those times when he can. I'm also telling you, Mr. Arnson, my personal policy, all right, I don't know that it's a good one, but is the person who moves away does more of the transportation than the person who stays. I'm not going to make her necessarily meet halfway, but she can go a little bit of the way there because normally they'd have to drop off anyhow. I'm not giving her a free ride, but I'm giving her, your client's going to do probably at least 3/4 of the distance. All right. And if your client's going to have Logan with him, he's got to make sure he gets to work. I'm not going to let him it's just like going to school. All right. Can't use that as an excuse. So,
Your Honor, I think one of the issues is this unilateral decisions being made, him getting a job and Mr. Oaks not even being aware of this. And
I understand he can be told, but quite frankly, if you have a hearing with me because you can't agree, I'm going to let the kid go to work.
Understood.
You know that.
Yeah, I understand that. But again, the lack of, I think the issue underlying here is this unilateral decisions and lack of communication between the parties.
Well,
I have emails and pages that I tried to send to the court yesterday. I went down to the courthouse showing all of the proof that I contact Mr. Oaks asking about whether or not he's willing to help with financial part, with transportation for our daughter's volleyball. He does not respond. I do not make any decisions without communicating, but there is a lack of communication that comes from Mr. Oaks because he doesn't respond. So in order to allow the kids to go to camps and to participate in sports, I have signed them up because every kid should be allowed to play sports or go to sleepovers or have jobs. They shouldn't miss out because their dad does not communicate. And every time he says, I can't financially help you because I'm not in that financial situation. That can't be the answer for everything these kids want to do from here until they turn 18.
I don't know that we're accomplishing anything here now because what you're asking for is more like child support and all that kind of stuff. If the parties are not going to cooperate and do all that, ma'am, if you follow the rules for legal custody and show that you can, when Mr. Oaks comes in and says, hey, I didn't know this and that, you show me that there was and this kind of stuff, he's not going to win those complaints. And that's why I'm happy that Mr. Arnson's on this. All right. Because Mr. Arnson, you can send the stuff through Mr. Arnson too.
But he has been in on all of the communication, which is what my legal counsel told me to do. So everything that he's stating
your
that
legal
I'm not
counsel?
communicating, I
How-
have.
How is your legal counsel? Who's your legal counsel? Why aren't they here?
Because right now I can't financially afford to have legal counsel because I'm covering all of the responsibilities of the
Don't
kids.
tell me you got legal counsel, all right? That's just whatever it is. I'm telling you right now that if you follow legal custody rules, informing him of this and that, and you can show it, he's not gonna be able to come back and say, she made a unilateral decision to move the kid, all right? Just keep track of it, all right?
So what do I do when he's
Doing
agreed to
anything-
things and then he doesn't pay for things?
Well, what does it say in your judgment?
I don't think it's clarified. The only thing that's clarified is the homeschool responsibility needs to be agreed upon up to a certain cost.
Okay. And if the two of you haven't figured anything else out, then I guess maybe you'll make a motion to come in and say, I want him to pay a certain part of it. This is gonna be the part of mediation that everybody's gonna have to sit down and work out, all right? Because this 50-50 that was great less than 2 years ago just stinks since then. All right, you guys have come off the rails altogether.
I don't have a problem with 50-50 as long as he's actually doing it, because I've had the kids since he's moved to Hesperia. He has not taken them on his week. He gave them up 2 weekends ago because he was sick. He keeps making excuses because he doesn't have a vehicle.
But if he's sick, work with him just like if she's sick. But
when I'm sick, I have my kids. He hasn't drove the kids to school since February.
Right, what do you want from me, ma'am? You just keep throwing this stuff out. What do you want?
I would just like something clear cut so that we don't have to keep coming to court and
what do you want clear cut?
I would like
I'll issue
him
an
to
order that you two got to cooperate and be decent parents.
all I'm asking is that if we still have 50-50 custody, that there is a plan laid out, which is why I asked him to go to mediation. It is an hour and a half from his house to my house. His solution was that I meet him in Kent City on his weeks at 6:30 in the morning to get the kids, and then meet him again in Kent City at the end of his workday. That's not 50-50 custody.
That's not gonna work.
He's got to figure out how to get the kids to my house for their schooling responsibilities and to get our daughter to and from school, to get our son to and from work. Our son did driver's training the entire month of May. He did not help at all. He said he couldn't because I was the one who signed him up and it's not his job to take him. So I did all of that, working a full-time job. There has been no 50-50 custody. That's why I'm here.
Mr. Arnson, I'm gonna tell you, you need to talk to your client about some of this stuff, okay? I trust you implicitly to, you know the law and you know this kind of stuff, all right? And she's right, we're not gonna work it where she's gotta drive to Kent City every morning to get the kids, when he's got them, to get the kids down to school, all right? If he's got the kids during the week and they're going to school, he's responsible for the transportation. And you're arguing, it's an hour each way and they can do that? Yeah, they can do that, all right? But it's not gonna work the other way. That's why I'm gonna suggest, where did you want to go to mediation, ma'am?
Through the front of the court. I've tried to do that with Mr. Oak several times, and every time I've offered mediation, he does not respond to me. I did not want to come to court. I wanted to go to mediation.
You're here. I don't want to go through that anymore. Okay, you're here, and maybe he's the bad guy. I don't know. I don't care. I just want to start getting to a solution. Mr. Arnson, you offer any solution? Send this to mediation.
I think I can talk to my client. I think mediation at the front might be helpful. Mr. Oaks, are you agreeable with that?
Yeah, I can do mediation. That's fine.
All right. And dispute resolution center or what?
If the court has any preference, I know they do mediation, voluntary mediation through the front of the court. And then sometimes the dispute resolution center is helpful. Obviously, there's privately private attorneys who provide mediation. They're a little bit more costly for these folks, though. So I would suggest either the DRC or front of the court.
All right.
If Ms. Behrens is comfortable with friend of the court, then we can probably make that work.
That's fine.
Draft an order that sends this to the front of the court mediation. I think somebody's trying to break in your window there, Mr. Aronson.
Someone actually did try to break in, a couple days ago. So we have window repair guys looking and giving quotes. So,
In this case, all issues will be sent to the friend of the court for mediation, and I want both parties to, if I find out that nobody's there in good faith, it's not gonna go good for them. You know that.
Understood.
And so I want everybody to go there in good faith and see if we can resolve these issues like schooling. Mr. Oakes, your son can work. If she had asked you, can he go work at Walgreens or whatever, and you had said no because it's too far a drive, you're gonna lose that fight in front of me. Your son
No,
go
sir,
work.
can I speak on that, please?
No,
what was that?
no, because we're done with this. I got so many more motions and it's 1 o'clock already. I don't need to hear anything because I'm just telling you, he's gonna go to work, and if he.
I want him to go to work, but I tried to give a solution
You
that
got
would
him,
work.
you're gonna have to be responsible to get him there, all right?
Sure.
That's the way it is.
And our daughter is allowed to play volleyball and attend
Is that
the,
through the school?
it's through the school. She has open
That's the-
volleyball twice a week, all summer long.
Well, is that voluntary type stuff, or is this for the volleyball team?
It's for, so in order, with volleyball, she wants to try out for JV. It is a unsaid mandatory thing. If you want to try out, make the team, you make yourself present. So the coach can see you, get to know you, see your positions, hands-on. And she did it last year.
If the girl's gonna be there 50% of the time, this is a school event, and if she needs to go to volleyball, she needs to go to volleyball. That's, I mean,
It's not a school event, though.
What?
That's not a school event, though. It's an
At the school, isn't
extracurricular
it?
event.
It's at the school, isn't it?
Correct.
And she's trying to build herself up to be able to be on the volleyball team?
Okay, so as long as we're clear, if I schedule things in Hesperia for the kids on her week, she has to drive out here to get them to those things, correct?
First place, you're not driving to her house. Second, it depends on what it is. I'm not just gonna let you just schedule a thing. This is a school event. You gonna put them in the Hesperia school?
I would love to.
Well,
I
you
would
don't
absolutely
have
love
the
to.
option right now, and they're not attending there. So no, if she's not gonna attend Hesperia volleyball, she's gonna attend where she is. You wanna have a hearing on where the kids should go to school? We'll schedule a Lombardo hearing.
Yeah, I just kind of going back to the issue again is the lack of communication, signing the kids up for things. You know, many of these things are not mandatory, but they're kind of, they're helpful. But
I'm here for the kids.
The parties should be able to talk about any scheduling conflicts and try to resolve the things rather than just saying.
They should, we'll send it to the friend of the court for mediation, but I'm telling you that in the end, if it's a school event and they're trying to do stuff with it, it's going to happen. I'm here for the kids. The kids go through school one time. They get to go to high school one time. And I don't really care how inconvenient it is for the parents, because quite honestly, my kid played hockey and I had to take him down to Nashville on a weekend and drive as fast as I could so he could be down there. It was tough for me. I drove him to Detroit on nights for practices. All right. Really a pain in the neck. Loved it. He gets only one chance to do this kind of stuff. The parents, it's tough for them. Yes, it is. All right. But that isn't my concern. It's my concern is that the kids get to be kids and do these things. Yes, ma'am. If you're signing them up, you need to contact Mr. Oakes. If he says no, I'll have a hearing and I can tell you pretty much where it's going. But
What do I do if he doesn't respond?
just if you've told him and he doesn't respond, sign him up.
Okay.
Because you're fulfilling your legal custody. We'll send this for mediation and probably come back sometime after that. You can renotice this motion if mediation is not successful.
Okay.
Mr. Arnson, anything else?
Nothing, Your Honor.
I'm not saying there's enough for Vadvarka right now, but we'll see what happens after this. Nothing has changed. Still 50-50 and all that kind of stuff right now. There will be, I am going to issue something. What is an area where we should drop off the kids? Ma'am, I don't know where you live. I know where Hesperia is, but
I'm in Greenville. He's in Hesperia. So from my house to his house is an hour and 20 minutes. Right now we're meeting, we were meeting 4 minutes apart.
And all that kind of stuff right now. There will be, wait a minute, all right, go ahead. I'm talking to myself somehow.
Before he moved, our meeting spot was about 5 minutes from his house and 5 minutes from my house. I told him I was willing to meet at the Log Cabin gas station, which is it's still in Greenville. It's about 12 minutes from my house.
Oh, Greenville, does he come down 131 or something?
I don't know. I'm not sure where he's coming from.
How does he get to the house to pick up the kids?
Well, it depends on if I'm coming from work or if I'm coming from the house. I'm usually coming from work, so.
Where is work?
Work is in Walker.
All right. So, and how, you come and you pick up the kids at what, in Greenville normally now?
That's what I've been having to do at this point because it's, you know, we
How do
hadn't
you
had.
go- When you leave and you go back to Hesperia, how's the direction that you go? What roads do you take?
I take Maple Island is the main road that I take to home.
All the way there from Walker?
From Walker, I take 96
Yeah.
and I get off at the Nunica exit, and then I take Maple Island all the way home.
Well, you're gonna
That's
have
the opposite that's
Yeah.
the opposite direction.
Yeah,
So.
you're gonna have to come back and pick up at ma'am, I don't know how far are you at, anywhere near, I know it's a ways, but Greenville, you can go right up 14 Mile Road to 131. Just straight to there and drop off the kids there and come back. I don't know where you live in Greenville.
What do we do for, I mean, like you said, we want a plan going forward. So
That's
for
what
next
we're doing
school
for this.
year, what was that?
We're not getting to that yet. 'cause
Okay.
I don't know. All right. You can meet at 131 and 14 Mile Road, that right there. I think they probably have a park and ride there.
They do.
They do.
All right.
And then he's required to get our son to work and back.
I've
He
already
works
made
all
that
weekend.
clear is that if he's got your son is not to miss work.
Okay.
Don't care how it gets figured out. Friend of the court for mediation, exchange will take place at 131 and 14 Mile Road. That's the only thing the order right now. Mr. Arnson, I'm gonna give you the honor of drafting that.
Okay, very good, Your Honor.
Thank you very much.
Can we do a set time on that so we don't have to do the communication every day?
Don't you, I mean, you're not exchanging every day. It's week on, week off.
I have the kids in the summertime.
You
That
have
has
all
been,
the time?
yes, they come to my house during the summer. That has always been a thing. That is in the judgment of
That
divorce.
should not be a thing. That was supposed to be up for negotiation, and she has continued to keep them. I would like to get that resolved as well.
Is it in the judgment of divorce?
It is in the judgment of divorce, and it was in the most recent order that Mr. Arnson filed with the court in, I think it was November.
It's week on, week off. That is what it's supposed to be.
Hold on,
That's
let
why
me-
none of this works. That's why
When
none of
is
this
it in
works.
the judgment? Tell me somewhere it is.
I think it was November 11th was the last thing that Mr. Arnson had sent to the court. I had it written down, but I don't see it at the moment.
November 11 of what year and what time? And
Of
Mr.
23.
Mr. Arnson?
Oh, I have it right here, Your Honor.
The October referee recommendation order after October 6th hearing.
It was November 21st.
From the October 6th hearing?
Yes.
And what does it say, Mr. Arnson? I'm sure you got it in your file. I'm sure I got it here, but it's gonna take me forever to find it here.
It just says the summer parenting time shall continue as previously ordered unless either party requests a review.
All right.
Okay, then I request a review.
So I believe that would be appropriate for discussion at mediation as well.
Yep. All right. I'm done. I'm done. That's the order that says the order. Good luck. We'll see you back, I'm sure. We're adjourned.
Thank you, Your
Thank
Honor.
you.
Can you tell me your name, please? What's your name? Cassie Briggs. I can read your lips, but I can't, and you cannot be driving while you're on this. I can't hear you, and you can't be driving. I'm not going to listen to anything more, even trying to get it until you pull over. Is Mr. Palet here? Bosco? Palet? Never checked in?
Can you hear me now?
Yes, I can.
Okay, I'm gonna pull over. I'm sorry, we were in Ann Arbor for my daughter's appointment. We had to leave the hotel at 11. I
That's
didn't know what
fine.
to do. If you could give me 5 minutes to pull over, please.
I haven't touched it.
Got 1 mile for my next exit. I really don't want to pull over on the highway.
Briggs versus Palet. As Briggs is on Zoom, Mr. Palet has never been on or has been in the courtroom. This was his filing for custody. There was a 5/22/23 order, primary physical to mom, joint legal. Dad now complains about the child missing school and failing grades and whatnot. Father is not here, has not been present at any time that we know of. During this, it was originally scheduled for 8:30. I'm at almost 1:10 by now. Been hearing cases all morning long. Quite frankly, him not being here means that I'm going to deny his request, as he has not been here to perfect anything that he says. So the court is going to deny his request for change of custody since he is not present. All right.
Okay, thank you.
Thank you, ma'am.
Yep.
Good luck. Drive
Thanks.
safe.
Yep, thank you.
Wiersma. Mr. Mitz is present with his attorney, Mr. Hexel, and Ms. Wiersma is present on Zoom on her own. This is apparently the father plaintiff has an ex parte order from the court. There was originally, the only judgment of custody that I have shows 50-50, and that's from back from 2015. There are significant concerns about mother's mental health as outlined in the motion. And I guess I should say the response, because it's her requesting to set that aside. As I say, there are significant concerns that have been presented to me, and they are through a therapist and through people at CA Frost, which is where I believe Ira attends. Is that correct, Mr. Hexel?
That is correct, Your Honor.
And so I'm assuming that you are asking that it remain in place, or what? Well, ma'am, you're asking to set that ex parte aside, right?
Yes, I am, Your Honor. I'm not suicidal, and I can explain how that is if you would like.
I mean, what do you mean you can explain what?
Well, I'm being accused of being suicidal, and that is not exactly the case.
I don't know how you can not exactly be the case. It is or it isn't.
It is not the case.
I have documents here from the school.
I've seen that, yes.
Very, very concerning.
Being rudely misunderstood, Your Honor.
Well, they don't seem to think they were misunderstood.
It was not a nightmare. It was a CPTSD-induced night terror. Mentally, those things are not the same.
So what is it? I mean, what are you trying to tell me? I'm not even really sure. There's school officials who are very concerned about you, and we're contacting you. I don't care where it comes from, whether it's wherever, okay? But you were clearly calling them, and you called Ira, as I recall, one time at school, and just had to talk to him and all this kind of stuff. Very concerning behavior, I'll tell you that.
I was trying to pull myself out of the night terror, Your Honor, and I understand that's actually the only time I've ever had to call him at school like that. I wanted to hear his voice in an attempt to pull me out of the night terror. I understand now.
I'm not really sure that Ira should be the one trying to fix your mental health issues
now, and that will never happen again for many reasons.
What do you mean for many reasons?
Well, me calling did not do any good. It only did damage to my child and me. So
are you in control of these terrors or whatever?
Yes, I am. But right when I'm coming out of it, I am in between a sleep state and an awake state. And these are things that under mental health, can be explained by my therapist, who is glad to interject. She has already spoken with me about that.
Mr. Hexel, interested in hearing from you.
Yeah, Your Honor, these letters are extremely concerning. Specifically, we have one from the therapist that speaks to what impact these kind of inappropriate conversations are having on the child. We've also filed a motion for change of custody that didn't make it up this week, so that'll be brought before 2 weeks. We're asking that the court continue to keep this ex parte order in place. These school professionals have had concerns. There's no reason for them to lie. Clearly, based on what the court's being told today, there are some concerns about mental health. We're looking to protect Ira and keep him in a safe environment. The parties have exercised supervised parenting time at Journeys, so they're already established with that. We would ask that that continue through the process, and that maybe the court would grant some resources from the court grant to allow Ms. Wiersma to participate in the supervised parenting time.
Has it been set up at Journeys?
They've already exercised one session last week, so they're already all set up.
All right. Is there another one scheduled?
There's not.
Ma'am, you exercised one last week?
I did. I am unable to pay for that. I am disabled, but I just found out Biden approved $600 payment for people on SSI and SSDI. So I will have extra money for the plaintiff's concerns. I actually asked the plaintiff for help with my insurance, and he chose to get a lawyer instead of helping financially stabilize the household.
That's his right. All right. Okay.
Well, in the mediation agreement, it says he'll help if he can, and obviously he could and just did not. So.
Well, maybe he can't. I don't expect anybody.
He can afford a lawyer. He could afford it.
Don't interrupt me. I think it's appropriate that he hires an attorney. This is the custody of your son. This is one of the most important things he's ever going to be involved with. So there's nothing wrong with that. So anyhow, the ruling of the court today will be that I'm not going to dismiss the ex parte order at this point. We're going to have a motion in 2 weeks for custody. It does appear that there's proper cause or change of circumstance to allow for an evidentiary hearing, but I guess I have to wait for 2 weeks to even see that. Although, there's a custody motion. Did you serve this on mother, Mr. Hex?
I did, Your Honor. The clerk's office never sent it up, but it was properly served. It was emailed to her last Friday. She received it and responded.
It was emailed to her last Friday?
Correct.
All right. Ma'am, you saw this motion for change of custody?
No, I did not. I saw the motion the lawyer sent me.
Well, his motion is for change of custody and parenting time support. So if you saw the motion, you saw the motion.
Okay.
You did or you didn't?
I missed that part of it apparently.
Well, I mean, I just hate to come back because with the situation that I know right now and everything.
What am I supposed to do to the more that I could do? I've filed papers. I've given you my mental health therapy. I am willing to sign a release form to you, Your Honor, to prove my sanity.
Sign it over to Mr. Hexel.
I don't want to sign anything over to him.
I can't read stuff that the other side doesn't get. You can't give me private stuff. You say, here, you can look at my mental health records, but the other side.
I have a no contact order with the plaintiff for a reason, because anything I tell him, he obviously uses against me. He isn't concerned about my mental health. If he was, he wouldn't be personally attacking.
Let's stop right here, right now. Let me talk. I cannot accept evidence that the other side doesn't get a chance to see. Plain and simple. Mr. Hexel can probably actually subpoena some of these things and stuff like that. All right. And you can do whatever you want with it. I'm a neutral party. I can't, just like Mr. Hexel can't give me stuff that he doesn't give to you. That's the only reason why I'm not hearing his custody motion today is I'm not sure there was proper service. Mr. Hexel says it was sent, but I think she has to receive personal service, last Friday. And you're saying you're going to hear it in 2 weeks anyhow. So you got notice of it. I'm sure it was in the mail also to you.
I've never gotten anything in the mail.
Or will be. Just let me finish. Or will be in the mail to you, and you'll have notice 2 weeks from now. He's basically fallen on his sword and said, yeah, we'll hear it in 2 weeks. It seems like a waste because there are significant mental health concerns. There are letters that I have from independent people at the school and whatnot that are concerning. So I'm not going to relieve you from that order at this point. The other thing is I will allow supervised parenting time at Journeys for right now until further order of the court. I will see what I can do as far as, money from the grant for it to be. And I'm also going to split whatever else is left between the parties. Mr. Hexel, whatever's left, the two of them have to, so it's not only her burden. All right.
Understood.
We will work on whether or not we're going to have a custody hearing, and it'll probably come up next 2 weeks from Friday, and I'll have to make a determination if there's proper cause or change of circumstance to have an evidentiary hearing on custody.
Okay, I will subpoena my therapist so she can testify.
I don't know for when. I don't have
in the next 2 weeks, I guess. I have to prove my sanity apparently, so that's what I'll do.
You don't know what's going on. I would suggest you employ an attorney, but that's all right.
I am disabled. I cannot afford an attorney.
However, that'll be in 2 weeks. Ma'am, I don't take testimony on Friday mornings, just so you understand that. Good luck, everybody. Mr. Hexel, you'll draft the order. All right.
Thank you. Yep. Thank you, Your Honor.
And we will send in the referral to Journeys. Okay. Because you can't do that. All right. But draft the order that says what I said about the ex parte and that we will refer it to that for parenting time. She can have up to 2 hours a week at Journeys. Cost is split, that which is not taken care of by the grant. Good luck. Thank you. We're adjourned.
Thank you.
Is there an end in sight, you think? See, because Peter's gonna be complaining because you had to go over there at 1:30. Good.
That's the thing. Okay, so with this one, the defendant did log in, but she's since logged out and is not returned.
All right. This is the matter of Wynn versus Halong. The plaintiff filed a motion here to find that the child was born out of wedlock. This is a DO divorce. Excuse me. However, it's my understanding that, ma'am, you were pregnant. Have you had the child yet?
Yes.
Okay. And you're claiming that it is not Mr. Halong's child, correct?
Yes.
We'll issue an order requiring the child and the father to participate in DNA testing. The cost will be split between the two of you, and I'll reserve who has to pay for it all at another time. But so that it gets done, and get the child and the father. There will be an order requiring him to go to DNA testing as well as the child. Once you get that report, I assume it will come back that will show that the father is not the father, Mr. Halong, and we can find that the child is born out of wedlock and can proceed with your divorce.
I thought like a lady in the legal assistant, she told me like you don't need to do like a DNA test something, just like
well, she told you wrong because I need to know that Mr. Halong is not, and the DNA testing will show that unless you have the father who clearly is the one. Somebody's got to present me with a DNA test. I'm not just taking your word.
So even like we all know, like I'm sorry.
A DNA test will show. All right.
Oh, so I need to go to the.
You get an order saying for DNA, talk to your soon-to-be ex-spouse, set it up where you guys go there, do a DNA test. It'll come back and we'll all be fine with it. All right. And the court shall do a DNA test on these kind of cases, is what it says. Okay, so we'll get you out that order, get Mr. Halong and your child, the newborn child, into the appropriate place for a DNA test, have it done. Should be simple. I should be able to get it back fairly soon. You'll provide it to me. You'll renotice this motion, and you'll show me the test results that show he's not the father, and everything will be great.
Okay. And do you need to see how long? Because like he been working now. He told me if I can contact with you, like tell him so he can log in back again.
Well, he logged in and logged out, but it's not going to change anything that I do. He's going to be responsible to do the DNA test.
Okay, so you don't need him, right? I just need to tell him that.
I don't need him because you're asking that he's not the father. And at least at this point, a DNA test is important. We'll worry about the other point later on where he might have to log in. All right?
Okay.
Good luck. Thank you.
Thank you.
We're adjourned.
Hello?
Hello, sir. Can you hear me?
Yes, sir.
You got to pull over. I can't talk to people while they're driving.
Yeah, I was in the.
That's fine.
I was in the court, and they told me to go home because I was waiting from 8:30 in the morning.
That's fine. I've been working since 8:30 on these things. I have to have you pull over.
Okay, sir. I'll pull over in the next exit right here. Yeah, some lady told me, no, you just go home. Oh, okay.
You can do Zoom from home or your car, wherever you want. You just can't be driving.
Yeah, okay, sir. I'm parking right here.
All right, this is the matter of Sedra versus Sedra, a case of motion that's been filed by the defendant father regarding child support. Says he hasn't worked much as he's disabled. Oh, and for the record, the plaintiff mother, was she served this motion? Did you give it to her?
Yes.
Like how long ago?
Last week, I give you the legal system and the first floor. They told me I got to give you to her one copy.
Okay, so would you handed it to her?
Yeah, I mailed it, and she have it. She have it.
You mailed it to her when? 5/8?
Maybe 10 days ago.
All right. This is a motion that's been filed. As I say, the mother of the plaintiff did not appear. She apparently has sufficient notice. It's a motion from the father regarding child support. There was just a child support order entered not even 2 months ago. without objection. Nobody objected to it. No information for the child support order was provided by the father. And now he wants me to do something to change it because he doesn't like it. Why didn't you cooperate last time?
I don't understand. I went to the front of the court and explained everything what I do after my surgery, because 4 years ago I have a surgery in my spinal vertebra 2 times. And
The friend of the court contacted you for information so they could do a child support order, and you didn't contact them back. Why?
oh, sir, I remember they give me some papers. I never fill it out. Yeah.
Yeah, that's what they worked off of. That's your fault. Second, they sent out this thing to you back in like February or March saying they're going to enter this order if you don't object to it. You didn't object to it. So they entered the order for $849 for 2 kids. You didn't object to it. You haven't done anything that's requested so we can get to the right numbers.
I went to many times. I give you the paper from my daughter that I was doing last year. And I told them what I was doing. To the friend to the court. They got the copy, everything.
When did you give it to them?
Like 1 month ago. And I was paying.
That was after your order was already entered. You know,
yeah,
the friend of the court has a tough job, and they do all this stuff, and they send out, you don't respond, they figure stuff out, they do it, they give you a chance to respond, you don't do it, and then you don't like what comes out, and then you go there, and now they've got to go do a whole bunch of extra stuff. That's just extra stuff that they have to do because you didn't do your job.
Sir, I went every week over there and talked to them. They asked me for a doctor paper, so I bring you the doctor paper to them, and I told them I want to pay child support because even my ex-wife, she said she knows that I'm disabled, that I can work full time. I told her no, I want to pay it because now I can work and I can do Lyft and Uber.
Listen,
I can make some money. I'm ready to pay it.
Listen, I'm gonna give you one chance, all right?
Yes.
And that is, I'm gonna send it back to the friend of the court for them to reconsider your child support. It's not gonna change, and you're still due that amount of money from February until June 1, and we'll see what happens from June 1. They're gonna send you information. They better have your correct address because that's where they're gonna send it to. You got to notify the friend of the court where. They're gonna ask for documents. If you don't cooperate with them, it's gonna come out the same. All right. So you need to cooperate with them and give them the information they ask for, and then we'll make another chance at whatever it is that's supposed to be the correct amount. I don't know whether it'll be higher or lower. I have no idea. If you're disabled, you provide the friend of the court with the information from your doctor or whatever. That's what you got to do. I'm not going to go through this again. You're either going to cooperate this time or not.
Sure, sir. Sure. Yeah.
I'm sending it to the front of the court. And as far as you're trying to forgive arrears and stuff like that, I don't even know if that's owed to the state. And if some of it's owed to the state, you can't forgive it. So that's the break.
Okay, sir. Okay.
So I will send a referral to the friend of the court for this. And as I say, you better cooperate with them or don't come back and ask for a favor.
Okay. Okay, sir. So is any way I can talk to somebody else in the front to the court like person, because every time I go they just told me totally different. To bring
I'm referring it to the friend of the court. They're going to send stuff to you. Respond to what they send to you.
Okay. Okay.
Thank you.
Okay, sir. Thank you so much.
You're welcome. Thank you. Have a good day. All right. I just ordered you and the newborn child to take a DNA test to prove you're not the father. Please cooperate. When I get the DNA test, we can get you off being the legal father.
That part, I don't know. We have to get a test?
Yes, a DNA test. It's a simple test. It doesn't hurt at all.
My religion don't say that we can test the DNA.
Well, I don't know what to tell you, but then you're going to have the legal father of a child you're not a father of. Sorry, the court.
So any way we can do beside the DNA test?
Well, I don't know of any. The mother didn't indicate that religion prevented you from doing a DNA test. The mother didn't indicate that your religion kept you from doing a DNA test. What is it that prevents it? I mean, it's just that they swab your cheek and they find out if you're the father or not.
Yeah, before we marry, she already got the kid.
Good. Apparently, goodbye. All right, what's the next one?
Walton King.
Hello.
Hello.
My wife would, so now I'm back.
There's a court order to take a DNA test. If you want to do something about it, I don't know what to do, but I gotta know you're not the father.
Yes, I am the father. I'm not.
I know
Yes,
that's
he
you
can't.
say, I gotta have
The
proof.
boy already.
The child was just born and you're married, so you're the legal father right now. I'm not gonna go through a whole bunch of stuff. I just ordered a DNA test. So if the mother wants to get it from you or she wants to get it from the actual father, she can do it. But quite frankly, I need some proof that you're not the father. Because you are married, which makes you the legal father. All right? Thank you. Oh, looks like she's asleep. Oh,
sorry.
that's all right. I know you've been on there forever, and I'm sorry. I've been working since 8:30 doing these things, so I'm sorry. Just, it is what it is, and I'm glad you got to get a little nap in there.
Thank you.
While you're doing it, we're here in the matter of Woods v. Woods. Plaintiff appears for this motion. The defendant has never logged on. Did you give him notice of this motion?
I did.
What'd you do? Hand it to him? Mail it to him? What?
I mailed it to him.
More than a week ago?
Oh, yeah. Yep. Early May.
The motion was filed like May 2 or something like that. I mean, it was a long time.
Yes.
As long as it was more than last Wednesday, meaning a week ago.
Oh, for sure.
All right. Then he clearly has notice. For the record, he has never logged on to Zoom for this hearing. So I believe notice is proper and I can deal with it. This is mother's motion, plaintiff's motion to extend child support until next year. The only question I have, you say it's Annalie, is it?
Yes, Annalie, my daughter.
You say she experienced setbacks in graduating. Has she been attending school regularly?
Yes, she has. Yep.
And she continues.
I'm so sorry. Yes, so she has been continuing school. She still has about 10 credits left that she needs to finish.
She's been attending on a full-time basis and lives with you on a full-time basis?
That is correct.
And is her expected graduation next May or before then or whatever?
So May, yes.
All right. Having found out that she has been attending school full-time, what school does she attend?
She's at Northview High School.
All right, know it well. As long as she continues to attend full-time on a full-time basis and is living with you, we will grant your motion to extend child support. Now, the most that it can go is until April 13 of 2025 because she's 19 and a half at that point. I can't grant any child support beyond 19 and a half. And my understanding is that she will be 19 and a half next year, April 13, correct?
Yes. Yes.
So I will grant it until April 13 of next year. Okay.
All right.
April 13 of next year, child support can continue unless she graduates earlier, then it stops. All right.
Okay. Yep.
So we'll set that up and
okay.
Send that through. You can go back to taking a nap if you want to, but you're in your car, probably not.
Yes.
Is there anything else?
That is all. Thank you so much.
Thank you. And thank you for being so pleasant considering it's almost 2 o'clock and you've been on here since I don't know when.
Okay.
Take care. Have a nice weekend.
You too. Thank you.
No, we're not done. You lied to me. You lied to me. I'm celebrating already. You're buying your own sub. Mm-mm. And you're buying mine since you lied to me, right? And just that. I mean, I can't blame these people. I get so frustrated when you call somebody and you can't get through and you sit there forever. But I don't know what else to do. It's not like I'm sitting here taking breaks.
Tracy also emailed them and told them to be patient.
Hello.
Hello, I can hear you finally. Mr. Edgerly?
Yeah, I heard you were a little behind.
Oh, geez, Pete. I've had like 35 of these today and they go on forever. You now are the last one.
Okay, well, Sean is not on the call. I can shoot her a text.
All right. Yeah, if you could tell her to log in quickly.
Okay. Yeah, I'm just did that now.
Is Emerson living with you?
Yes, he is full-time. He's on probation, the juvenile court.
In Kent County or what?
Kent County, yes. Juvenile court actually has an order for him to remain in my custody.
I was going to ask that. That's pretty strange. Because I have here has PO placed in Dad's home.
Yep.
Questions. All right, I'm gonna introduce the case, but if you could send a text to her to get on.
I did.
Ludwig versus Edgerly. this is a motion by Mr. Edgerly. You obviously gave her notice of this because you said she's gonna log on. She knows about it, right?
Yes, sir.
All right, and you gave it to her more than a week ago or something like that?
Oh, yeah. Yep. She had it in plenty of time. Yeah.
All right. I'm kind of gonna go slow because I'm gonna let her have an opportunity to log on. But we have the defendant, father, Mr. Edgerly, logged on here, and it's his motion for change of custody as it relates to Emerson. I know you have other kids, but this, you only filed as it related to Emerson, correct?
Yes, sir.
All right. Emerson is almost 16 years old. Dad has asked for a change of custody. He's made several allegations. Some of the worst, our mom has said, he's not allowed back in her house. He's been in trouble at the juvenile court here in Kent County. And apparently has been in Mr. Edgerly's home since the end of March. Is that correct, sir?
Yes, sir. This is actually the second stint of him being with me long term. The first time I did not file, well, I filed for all my children because they were all living with me, but Emerson did 8 months in which he wasn't allowed back at his mother's house, and he was with me full time, and I didn't file anything for that specifically.
I know you did. You filed for a change of custody for all the kids, and then in February of this year, you withdrew your petition, and we didn't do anything.
Yep.
Then now you're filing for Emerson. In effect, the court has placed the juvenile court has placed Emerson with you for his residence. Is he visiting mom or what?
No, he has not visited her at all.
Right. And who's his probation officer?
Kiana. Her name is Kiana. I'm gonna butcher her last name. Cruz.
Hugh, I think.
Hughes. Yep.
Hughes. All right. Well, whatever. I should know him because I do a lot of this stuff, but I don't recognize that name. All right. Sir, here's what happens. I can't really change custody on a Friday morning, but I clearly can find that Vadvarka has been met. Vadvarka says a change of circumstance or proper cause for Emerson. He's living with you at the direction of this court. So obviously he'll stay there. And quite honestly, no matter where he is supposed to live, if the juvenile court says, no, you go live there, that's where he has to live. Okay.
Yep.
He's living with you right now. We'll set up a brief hearing somewhere in the near future to change custody or to probably change custody. Like I say, it's just not possible for me to change it on a Friday morning. I can only find that there is proper cause or change of circumstance, and there clearly is because the court finds that it's more appropriate that he lives with you than his mother.
Yep.
Okay? So, and that's a change of circumstance. We're going to mail you something about a hearing date coming up. I'm not going to set it for very long because I assume this will be a relatively easy hearing since the court's ordered him to be with you. Does she object to this?
I honestly, I don't know. I haven't actually talked to her about it. I've tried to talk to her about it and she ignores me on it. We actually had a discussion about this in person. I believe it was a few months ago. And yeah, the communication hasn't gotten any better, but there was an altercation with her boyfriend, I don't know, 2 months ago, shortly before I filed for this, and in which he was removed from the home. And then other things came out that may be actually causing those charges against Emerson to be dropped. In return, here we are pretty much. So the court, I know the juvenile court pretty much just says it's in his best interest. He doesn't get in trouble at your house. He does what he needs to at your house. They think it's in his best interest for him to remain in my house.
Right. And then I suggest that when we have this hearing, you might want to make sure that the probation officer is present so that that person can be questioned.
I will definitely make sure.
Who is his attorney? Who is your son's attorney?
I cannot give you that name right now.
You're not going to give it to me because you don't want to, or?
No, because I can't remember her name. I've actually had very limited contact with her because, like you said, he's been at my house for the most part.
I'm just kidding. I'm giving you grief because I've been on the bench here since 8:30 doing things. Okay.
You poor man.
What is it? Megan Hunter?
Yes. Yes, sir.
I'm just going to suggest that you also contact Miss Hunter about this. All right.
Yep.
And tell her what's going on. You might get some help on how to do this evidentiary hearing and stuff like that. It's just something that I have to go through.
Yeah, no, yeah.
Right. And so contact Megan Hunter, contact the probation officer, tell them what's going on. You'll get notice of when the hearing is, and make sure that you contact them and tell them about it, and maybe they can give you some help on this matter, okay?
His PO pretty much said, like, you're taking care of this kid. She's not helping at all, like financially, nothing pretty much. And she's like, well, you gotta do this if you want help, because that's the only way we can make it happen.
That's right. And so, yes, I can't do much here today. Find proper cause, change of circumstance. We'll send out a notice for an evidentiary hearing. It might only be for an hour, because you can put stuff in here pretty quickly. All right.
Yep.
But talk to them. I mean, I'd tell you, you really should have an attorney. Maybe you need to talk to Miss Hunter about, tell her that I'm going to have an evidentiary hearing to get custody of Emerson. What can you do to help or something like that? The referee told me I should talk to you about it.
Yep, I will definitely do that. She actually supports this decision, because obviously it keeps Emerson stays out of trouble at my house. So, I mean, obviously at the end of the day, it's what's best for him.
Was his charge domestic violence or something against the stepdad?
Yes. Yep.
How could I guess that? I've done this for 43 years, and I've done delinquency for 43 years also, so I can figure it out.
Yeah, I was informed. Emerson did inform me. The reason that I'm kind of pushing this as hard as I am is because he said that during that altercation he was choked by his mom's boyfriend and assaulted and stuff like that. So I'm just trying to err on the side of caution here. I hate going in front of you guys, but I got to do it.
You. And you know what? I hate you coming in front of me too. There, we're equal.
I get that.
I've had 35 of these this morning, and so I'm to the end of my rope. But I understand, and I'm not going to try and make it difficult. But I am going to have to do my job.
Yep.
And
no,
job will be based on evidence, and that's why I really want you to talk to Miss Hunter. We'll get you in as soon as we can, and hopefully, I mean, this is really all going to be about Emerson, and he's got to just not get in trouble. End of story.
Yes, sir. I agree.
All right. Good luck to you. We'll see you whenever. We do have a good address for you. Don't tell me what it is, because I'm just going to say, is it still 3204?
Yes, sir.
All right. We'll mail it out to you so you have notice to be here for that hearing.
Yes, sir. Thank you. And you have a wonderful.
Thank you. You have a great weekend, sir. Take care.
Bye.
Thank you.